is on our YouTube channel, and then Jane's cram course is in Learn Test Pass. So you have access, not the one she just did, it was the one in March, I think, but you guys have access to both. So before this, let's first, and I did want to point something out real quick. My cram course, in addition, I also included my PowerPoints, and then there was like this extra little quiz. So just to point that out real quick, it's at the very bottom. So you guys see this folder called Julie's cram course. That's under Jane. So it has, again, my PowerPoint. You got the recording in our YouTube channel and the PowerPoints. And then there was like this little ongoing quiz. So what I did was just made it like a PDF so you could treat it like a real quiz. Because if you look at the PowerPoints, it tells you what the answers is. So I just kind of pulled it separate and then gave you an extra key so you could sit down and treat it like a real test. So that's that. Where we are right now, as a reminder, if you look in the welcome section of Learn Test Pass, we have North Carolina law and commission rule. So we're in the throes of talking about state-specific things. This is North Carolina license law and commission rule. This booklet is what's going to keep you out of real estate jail. I never want to see you guys facing disciplinary action. So keep you out of real estate jail. Follow the law and the rule. Isn't that what they always say? Isn't that what the police tells you? Everything, just follow the law and you'll be all right. So I'm telling you the same thing real estate commission is as well. Specifically where we are in this booklet, we have started on page 106 in the comments. So again, when we look at my PowerPoints in just a second, we're going to see page numbers, and the page numbers in the PowerPoints refer to this booklet. Yes, you have this as Appendix A in your book, but what is in Appendix A is out of date. So my suggestion, if you want the most current, which you're always tested on the most current. So my suggestion is to come here to Learn Test Pass and get this booklet, particularly where we are starting on page 106. So with that being said, a good part, one thing I like about this booklet, some of this stuff is a review. Isn't this a good time to have a review? So last class in this booklet, we talked about agency agreements. We talked about material facts. And then where we left off with each other the other day was our good review on the agency disclosure. Guys, you got this information in two places. You got it in license law and commission rule, and you got it in unit 7. What does that mean to you? Is it a little bit important? No, not a little bit. Really important stuff. And doesn't it make sense? I mean, agency defines how we work with buyers and sellers. Agency defines how we work with owners and tenants. Agency defines how we work with the people. So that's why it's so heavily tested. That's why we get it twice, because we need to know as agents how we want to work with the people. So good morning. So agency disclosure, when we talk about agency disclosure, we're talking about our working with real estate agent disclosure. This is in no way a contract. Agency disclosure does not create agency. Is that worth me saying again? Agency disclosure does not create agency. Our agency agreements create agency. Agency disclosures is just that. It's me disclosing my agency status. I owe it to the consumer to let them know, ideally in a perfect world before first substantial contact, who in this transaction I represent, who has my loyalty, who currently has my old car. The biggest piece of this form is to let the consumer know, don't you tell me anything confidential until you decide to hire me. Guys, please remember, I tell my client everything about my customer. What do I tell my customer about my client? Nothing without their written permission. Everybody with me? Isn't that only fair to let the consumer know? would you feel blindsided if I let you tell your life story and say, well, as soon as I share that with my seller, now you kind of feel blindsided and you don't feel like you can trust anybody ever again, right? That's what we're doing, you guys. We're letting them know, we're putting them out there early on. Again, ideally, we're doing it before first substantial contact. However, we don't live in a perfect world. And so we may not always get to know when first substantial contact's coming. Sometimes it just happens, y'all. People talk. I mean, we talked about this last week. You guys ever have a perfect stranger walk up to you in the store and just start sharing their life story with you? People talk. And that's what we as agents need to be on alert for. When they come up and start, oh my gosh, I got to buy something in 2 months and it's really dire because I got a job relocation and my wife is 4 months pregnant. So I really want to get in before. Did I just learn a whole bunch of things that could affect their negotiating power? You bet. So when I'm presenting this offer to my seller, I say, I know for a fact they need this house. I know for a fact they need a deal. So what are we going to do? We're going to, you guys with me? So the whole point of this form is their Miranda rights. Anything you say can be held against you, not in a court of law, but in this transaction. How could this affect you in 123 Main Street? Agency disclosure applies to all sales transaction, residential sales, commercial sales, agricultural sales, industrial sales. Sales is sales is sales. So we use this for sales transactions. So commission rule says disclosure of agency status by seller's agents. If you're a seller agent and you're communicating to a prospective buyer, you're a seller's agent or a sub-agent, you're communicating to a prospective buyer. We do our disclosure. I should say disclose our status no later than first substantial contact. This is the scenario. I'm doing an open house on Sunday. Maybe I'm the listing agent. Maybe I'm another agent in the firm. I'm doing an open house on Sunday. Who represents the seller? Who represents the seller? Anybody want to venture a guess? Who represents the seller? Not the agent. That's right, the firm. There we go. So if it's not your listing, could you still do the open house as long as the firm has the agency agreement? Yeah, because we all have that duty to our seller, right? Y'all always need to stop and ask, who does the firm represent, not you, the individual? So you're doing an open house. Buyer walks in the front door and launches into why they have to buy, how soon they have to buy, and how much money they have to buy. Commission rule says we need to do our disclosure no later than first substantial contact. So you're the seller, seller's agent. Rules are a little bit different if you are already been hired as a buyer's agent. Rules are a little bit different if you've already been hired as a buyer's agent. And what that commission rule says is that we have to disclose our status of being a buyer's agent at initial contact. So let's talk about the difference in first substantial contact and initial contact. First substantial contact is when I start learning relevant information about the consumer, about this transaction. I don't care what you had for lunch today. I don't care what color underwear you're wearing. What do I know about you in this transaction? First substantial contact. Initial contact is, hi, my name is Julie. Everybody hear the difference there? So when you're already been hired as a buyer's agent, so let's walk through a couple scenarios. Let's say your buyer calls you and says, there's a property at 123 Main Street I want to see this afternoon. And you say, great. And your buyer says, I have a couple questions about the property though. Can you find out for me? And you say, of course. So you get your buyer's questions, you contact the listing agent and you say, hi, my name is Julie, and I'm working with a buyer that's interested in your property at 123 Main Street. The only other thing you knew about me at that point is that my name is Julie. And that's just polite, right? The very next thing in the same sentence, I told you I'm working with a buyer's agent. Same thing for sale by owner. What if your buyer wants to see a property this afternoon and they don't have any questions? They just want you to schedule it and we'll meet at the house at 2 o'clock. When you go into the scheduling service, we have a program that we use to schedule all of our showings. And when you go into the scheduling service, you select the date and the time that you would want to see it. And then it asks you, who are you in this transaction? Are you a buyer's agent? Are you a seller sub-agent? So you check the appropriate box. And then the request is sent to the seller and the listing agent. And what they see on their end is, for example, Julie Campbell, comma, buyer's agent, comma, wants to see your property today at 2 o'clock. When did they learn about my status of being a buyer's agent? It was at initial contact. If I'm communicating with other agents, I obviously don't have to do the working with real estate agent disclosure. That's a consumer form, but I still need to disclose my status. I still need to say who I am, why I'm showing this property, if anybody I represent. Questions?
I have a question.
Yeah.
So initial contract is different from first substantial contract?
Yes, absolutely. First substantial is when I learn something substantial about you in this transaction. Initial is when I meet you.
Okay, got it.
By the way, we do obviously have to eventually put our status in writing the time we're ready to present the offer. Our standard offer to purchase and contract helps us with that. When we are listing our role as a selling agent or a listing agent, we actually check the box of who we are. We have to identify our role in this transaction. What allows me to be here in this transaction? So thank you, Forms Committee, for taking care of that for us so we don't have to remember to do it. Another big thing that we talked about in 7 that we're going to do a quick review on here again too is dual agency. Dual agency is intentionally created with, y'all want to say it with me? Informed written consent. Does dual agency just happen by accident? Nope, it is intentionally created with informed written consent. Can I look at my buyer and say, we're going to do dual, sign here? Is that giving them informed consent? So how do we get into disclose dual agency? We have a conversation about it. We discuss it with them. We tell our buyers and sellers, if we get into dual, if we get into a situation with dual agency, this is what it's going to look like. This is what you're going to give up. They have to agree. The big thing with dual agency, you guys, is that my advocacy goes away. Remember, who represents the clients in this transaction? Is it Julie, the individual agent? No, it's the firm. So the simplest breakdown of dual agency I can come up with is one firm, one transaction, 2 clients. Your seller has hired the firm. Yes, your seller has hired the firm to sell 123 Main Street. Your buyer client is interested in buying 123 Main Street. We are now in the potential for dual. Anything I do with owners, may that be for sale or for rent, everything has to be in writing from the inception. Everybody with me? I cannot do anything for the owner of a property without having a written agency agreement. I've got to get a yes or no to dual agency at the beginning because we complete our agency agreement as part of our agency agreement. Can the seller change their mind to dual? Can they come in later and change their mind? Of course they can. We need to get that change in writing. Okay, because they've already said yes or no in writing. So if they're going to change their mind, we are allowed, as we've discussed, to work with a buyer or tenant under an oral agreement at first. Dual agency with a buyer or tenant can be oral at first, but I eventually have to put it in writing at the time that I'm ready to present the offer. Can they change their mind orally? Sure. Here's the general rule of thumb. If they said no in writing, it can only be changed in writing. If they've said yes orally, we can change it orally. You cannot change a written with an oral. Can one broker represent the seller? Yes, dual agency can be one broker. It could be two brokers. It's not the broker representing the seller or the buyer. Who's representing the seller or the buyer? The firm. Remember our dual agency wall? Oh yeah, we got a wall for that too. Dual agency, you got buyer on one side of the wall, seller on the other side of the wall, the firm, and by default, all the agents in the firm are straddling the wall. There's your visual for dual agency. Dual agency is intentionally created with informed written consent.
Julie, I have a question.
Okay.
Now, in this situation, when we have test questions, will it say, and you might have said this already, but I just want to make sure, anytime there's a question that says broker, that is not the BIC, that's not BIC in charge. It will say BIC in charge.
If it's important to the question, yes, but the broker is usually referring to the individual agent. Yep.
I just had a lot of questions in there that confused me because I thought like the question meant the BIC. And it didn't mean the
You got to
BIC.
look at what the question says. So if it says broker, we're talking about the individual. If it wants to ask you about the BIC, it will specifically say BIC. Okay. There is a different type of sales that we put in a totally different bucket. We say we're not going to pretend that they exist unless we see a specific question about it. And that different bucket of sales is auction sales. Again, pretend that auctions don't exist. An auction is not a thing unless the question specifically says something about an auction. Auctions are a totally different category, totally different beast. We do not have to do our agency disclosure for auction sales. You're not going to have dual agency in auction sales. The auctioneer represents the seller. Maybe the buyer's represented, maybe they're not, but it's with an agent with a different firm. It's with somebody else. Remember we talked about auctions back in Unit 10? The auctioneer is actually serving as a general agent because they have the power to bind their seller. Y'all, when that gavel comes down and the auctioneer says sold, congratulations, we're under contract. What's the very next thing we need to do? Put it in writing. If the buyer is represented, then the buyer's agent needs to disclose their status as being a buyer's agent about the time we're sitting down to write the contract after the auction sale, when the auction sale is over. With auctions, you do not have to do working with real estate agent disclosure. Again, you guys, we do not have to do working with real estate agent disclosure. Again, pretend that auctions don't even exist unless the question says something about auctions. Everybody with me? Can you choose to disclose your status? If you were an auctioneer, could you choose to disclose? Again, you guys, your test isn't going to ask you what you're going to do. Your test is going to ask you what you can and cannot do. Commission rule says we don't need to disclose our status, don't need to do working with real estate agency disclosure. So putting auctions off to the side again. We're going to forget about auctions. A little bit more about dual agency. Again, in-house transactions. In-house means both sides are represented by the same firm, one firm representing both sides. Dual agency is always two clients. Good morning. You don't have any customers in dual agency. If you have a customer, you're not in dual. Dual agency is always two clients. Maybe it's one broker working with both buyer and seller. Maybe it's two brokers. Let's say you are the one broker in the dual agency transaction. You're working with the seller as the listing agent and you're working with the buyer. Because you're in dual agency, does that give you the golden ticket to share each other's confidential information? Now that you're a dual agent, you're a different role now, right? So does that mean you can call the seller and say, ooh, I know all the buyer's secrets. And you can call the buyer and say, I know how much under asking price the seller's willing to go. We still have to respect personal confidential information. We still have to, not run around blabbing everybody's information. We cannot discuss confidential information of one party with the other. Technically, we could discuss within the firm, couldn't we? Is that advised in practice? Would that be a good thing to do? Probably not. But technically we can, right? Because it's the firm that's representing both sides. Careful though, you got to start discussing your clients within the firm, and now you're not allowing yourself to be designated. No water cooler gossip. Everybody promise me? We're talking about the property. We're talking about the amenities, even in our office. Just because we can doesn't mean that we should. So designated dual agency is a form of dual, which means I have to have consent to dual before I get consent to designated. Think of designated as an extension of dual. If they say no to dual, designated is not an option. Everybody with me so far? I have to have 2 yeses to dual in order to get 2 yeses to designated. Designated is always 2 brokers. In designated, back to our wall, you got the buyer on one side, seller on the other. The firm and all the agents are straddling the wall. This is dual agency. What happens in designated is that one agent gets kicked off the wall to work exclusively with the buyer, and a different agent gets kicked off the wall to work exclusively with the seller. They've been designated. Once you've been kicked off the wall, once you've been designated, these 2 agents might as well proceed as if they were 2 different firms. I now have a duty to advise. I now have a duty to share the other side's confidential information if I learn about it. We might as well be with 2 different firms. Look at where the firm and the rest of the agents are. They're still in dual, aren't they? They're still straddling the wall. It's only 2 agents that have been designated. Everybody else stay in dual. Can clients agree to do dual and not designated? Yes. It's 2 separate agreements I need. I need a yes to dual and I need a yes to designated. Guys, please remember, not all firms offer designated. So it might not be up to the client. If the firm doesn't offer designated, it's an automatic no, right? So we can get a yes to dual, and then that's pretty much the end of the conversation. So the firm has to allow designated. Not all firms do. Please, please don't assume that designated is automatic. There are 2 caveats with designated. You cannot be designated if you have prior confidential information going into this about the other side. Your BIC should ask you, do you know anything? If you've been working with the buyer, the BIC should look at you and say, do you know anything about my seller that could harm them? If you're working with the seller, the BIC should look at you and say, do you know anything about my buyer that could harm them Again, it's about this transaction. We cannot be designated if we come into this knowing confidential information about the other side. Once you're designated and you learn something confidential about the other side, now I have a duty to tell my client. That's what we mean by being designated, is back to exclusive. And probably the biggest problem topic, I'm going to say in Unit 7, the provisional broker and the broker in charge cannot never be designated opposite of each other. Can they be in dual? Can a PB and a BIC be in dual? Shake your head one way or the other. Can the BIC and the PB be in dual? Yes. The BIC and the PB cannot be designated. They cannot be kicked off the wall opposing each other. It's the very nature of the relationship. We've talked about you guys as provisional brokers. I call you guys my brokers with training wheels. Your BIC is your training wheel. You cannot ride your bike unless you have your BIC's assistance, unless you have your training wheels. Theoretically, your BIC should be in your back pocket as a provisional broker. Your BIC was probably preparing you for your listing appointment if they didn't go with you. Your BIC was helping you gather information you need for your buyer consultation if they're not sitting there with you. And after these appointments, they should be following up with you. How did you go? How did it go? What did you learn? Da, 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 da. Just by the BIC doing their job, they should know something about the provisional broker's client. Everybody see what I'm saying? If they're doing their job, they should know something because they're there with you. They're your training wheels. They're helping you get through it. So due to the very nature of the relationship, these two can never be designated. They can never be kicked off the wall opposite of each other. Any other relationship is allowed. Broker and broker, broker and provisional broker, broker and BIC. Any other relationship is allowed as long as you don't have prior confidential information about the other side going into it. Questions? As we said, one more thing with dual agency. There's certain, just because you're dual agent doesn't give you this golden ticket to run around blabbing confidential information about one party to the other. Again, technically the firm can discuss it. What we're saying here is you can't tell the buyer the seller's secrets, the seller the buyer's secrets. Isn't that kind of the courteous thing to do? What questions do we have?
I have a question, Julie.
Yeah, please.
So if we are in dual and you're designated, you said that we can't have any prior knowledge of the other party.
Going into designation.
Going into
correct.
it. Now, once you're in designated, if you learn confidential information about the other side, you can stay in designated, but you just aren't allowed to share anything.
No, once you're designated, once you've been kicked off the wall and you're designated, you learn something about the other side, that's a duty you owe to your client to share that.
Okay.
That's why that's what we mean by being designated.
Okay. So we do have to tell.
Once
Our
you're
client.
designated.
Okay.
I just got this in the chat and it made me laugh. It's like our family game night. I'm loving this example. Dual, I'm helping both kids equally. Designated, I'm helping my daughter and my husband helps my son. Ding, 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 ding. Thank you for that. That's awesome. Congratulations. You just made it as an example to my future pre-licensing classes. That's exactly what it is. That's exactly, when you're dual, you're helping both kids. When you're designated, you're only helping one. We're trying to help them get through the game, right? We're trying to help them finish the game with following the rules and the laws. Anything else? I put agency behind us again. Okay. Continuing on with commission rule does address how we as brokers, when we are parties to the transaction. First off, let me say this. Sometimes there's and I don't know where this comes from, but sometimes people get this in their mind that real estate agents can't buy and sell their own personal transactions. Can agents buy and sell homes personally? Yeah, you know what we do all day, every day? You know, and it might be that's why you have your agent, so you can better, or you're here, so you can better assist yourself through the transaction. So yes, I can buy real estate. Yes, I can sell real estate. However, what I need you guys to understand is once you're licensed and you're buying and selling for yourself personally, you are now held to a higher standard because now you are the licensee in this transaction. Everybody with me so far? So you're held to a higher standard. Now they know that you know. Commission rule says when you're selling a property, you cannot represent the buyer in that transaction. Can I be my own listing agent? Can I wear two hats, listing agent and seller? Of course. Of course. I'm not going to pay you a referral fee to sell my house when I have a license. Are you kidding me? So of course I can wear two hats, listing agent and seller. I cannot represent the buyer in that transaction. Remember what old car says, I owe my client loyalty. So if the buyer hires me, I should owe them loyalty. I should have their best interest above all others. But let's face it, y'all, if my name is on the deed, whose best interest do I actually have in this transaction? Mine, all day long. Do you guys see the conflict of interest? Do you see the conflict of interest? The exception to this rule is if it's a commercial sales transaction. You're listing the property as the agent and you have less than 25% ownership. So commercial transaction, when you have less than 25% ownership, you can represent the buyer in the transaction as long as you give them full disclosure before you start. I own a 20% interest in this property that I have for sale. We've got to let them know. And as long as they agree to that. The other side of this, what if my firm has something listed for sale and I, as a personal buyer, are interested in buying it? My firm's representing the seller. Maybe I'm the listing agent, maybe I'm not, but I am interested in buying it. This is where we need to get our BIC involved. The BIC needs to have a conversation with the seller. Are you comfortable moving forward with this transaction with the agent and my firm being the buyer? We may have to, if you're the listing agent, the seller may want to refer it to another agent in the firm. The BIC may allow the seller out of the listing agreement, but the BIC needs to have a conversation with the seller. Again, it's all about full disclosure. We got a commission rule. We need to notify the commission whenever we change our name or address, both personally or business. So if you get married and change your name, if you get divorced and change your name, if you move, good morning. we have to notify the commission within 10 days of that change. Once you guys get licensed, you'll have a log on to the commission's website, your licensee log on. They make it so easy now. You can just log on to your account, update your information, and you are good to go. So if you move, if you change your name, always just keep your contact information updated with the Real Estate Commission. 10 days. There's commission rules about advertising. As we've been saying, I cannot perform a single service for an owner without first having a written agreement. I cannot put a sign in the yard. I can't do anything. One of the BIC's responsibilities is the advertising that goes out on behalf of the firm. So the BIC should review your advertising. And the BIC's looking for several things. First off, we're making sure that we have no fair housing violations, making sure that the information is accurate. Y'all know the internet, right? What happens when you hit submit? It is out there. So having a second set of eyes on it before you put it out there. Another thing that the BIC is looking for is the firm's brand identity. That brand identity helps the consumer, helps the public recognize the firm. Your firm will have a brand identity. There's logo, certain colors you can and cannot use. You guys with me? I mean, hello, Golden Arches. Isn't that the best brand identity I can think of, right? You see those golden arches and what do you think? Da, 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 da. So you're with me? And the BIC needs to make sure that all the advertising that goes out in behalf of the firm is properly represents the firm. So BIC's responsible for advertising, especially as a provisional broker. And guys, social media is advertising. And when it comes to advertising, commission rule says we can't have any blind ads. A blind ad is one that doesn't include the name of the firm. Always ask yourself, whose listing is it? So we need to make sure we're advertising on behalf of the firm. Putting the website in the advertisement is not sufficient. If your email address is, for example, julie@allentate.com, that's not sufficient. We need to actually say Allen Tate. Y'all think you should document your advertising? Would that fall into the category of everything? It takes a second and a half to take a screenshot of your Facebook post and put it in your transaction file. Questions on advertising? We got a commission rule on the delivery, I couldn't get that word out, of instruments. First off, let's talk about what the heck an instrument is. An instrument is just any document relating to this transaction. So it starts with our agency agreements, evolves into contract paperwork, and then eventually, fingers crossed, includes closing paperwork and anything, any piece of paper in between. Commission rule says that we have to deliver instruments to the consumer within 3 days. 3 days, this is 3 days of your receipt. So once you get that signed agency agreement, we have 3 days to send an email with a PDF attachment that says, "Hi, Mr. Seller, here's our signed agency agreement. I look forward to working with you." please note this rule says deliver. That's my job, is to get a copy of that signed document in their hands. What they do with it when they get it, it's no difference to me. Do y'all think you should document that sent email that shows the date and the time that you sent it? I think that falls under the category of everything. Are we kind of getting the big picture here of what we need to document? There's again, a common misconception that I'm going to wait until the end of the transaction when it's all said and done and send my client a copy of everything in one nice, neat package. And unfortunately, commission rule says we can't do it. Bottom rule of thumb, if they sign it, they deserve a copy of that. So they sign the agency agreement, send them a copy within 3 days, sign the contract, send a copy within 3 days, sign the closing paperwork. The exception to this rule is when I deliver offers to sellers. First off, who can remind me which offers I deliver? Which ones do I deliver to my sellers? Yeah. Yeah, all of them, every single one of them. And in this case, I have a duty to deliver all offers immediately, but in no event later than 3 days. So 3 days to deliver instruments from your receipt. They may sign it one day and you don't get it until tomorrow. So it's 3 days from your receipt. There's a commission rule. We've already said we document everything, right? So what do we do with all that documentation? Well, the commission's got us. They have a rule on retention of records. Says we got to keep everything that we document for 3 years from the end of the transaction. Whenever the last brokerage activity is done is when your 3-year clock starts. Successful meaning we make it to closing. Unsuccessful meaning we don't. Whenever the transaction is done, starts our 3-year clock. And please note too, this rule, it doesn't say it here, but this rule actually says at least 3 years. So 3 years is the minimum. Can you keep it longer than 3? Yeah, 3 year is the minimum. Yeah, we'll talk about trust account earnest money in just a bit. Yep. So we have a duty. Let's say, for example, you're the listing agent. And again, we're going to talk about earnest money in just a minute. Let's say your listing firm holds the earnest money. You guys maintain the trust account and you hold the earnest money. And we're going to learn in just a bit. Actually, you know what? Let's hold off on that example for just a minute. Is that fair? I'm going to retract what I say. So let's wait and we'll have this conversation in when we talk about the trust account. I think it'll mean more to you guys once we discuss the various rules of the trust account. Fair enough? So we'll come back to this. We'll see this. Okay. Commission rule addresses how our brokerage fees and compensation is handled. First off, I have a duty. I have to do a full and timely disclosure of compensation, bonuses, incentives. I need to share this information with my client in a timely manner. Timely manner is not sitting at the settlement table saying, by the by, as soon as you sign, I get a $500 bonus. That's not timely. Timely is before we present the offer. Our client should have all the information, including my bonuses, incentives, etc. They need to have all the information available to them at the time they're ready to present the offer. And we have to give full disclosure, which means I can't just say I'm going to get a bonus if you close. We're going to say I'm going to get a $500 bonus once you close. Some builders may offer, for example, a bonus. Some sellers, we're coming back in a market where buyers are getting control again. We might start seeing sellers offering bonuses again. Just our clients. We have to disclose to our clients. Y'all put your pencils down for just a second. Let's walk this through. Why does the buyer care if you get a bonus? Why do they care? All right, we all know the seller pays commission to the listing firm. The listing firm shares their commission with whomever's bringing the buyer. So the seller pays the commission. Everybody good with me so far? Typically, seller pays the commission, debit the seller. The commission is based off of the sales price. Who's paying the sales price? Who's paying that amount? The buyer. So why does the buyer care if you're getting a $500 bonus? Because it's quite reasonable that the sales price has been jacked up $500 for you to get the bonus. Everybody with me? Does that make sense? Isn't that information they should have going into it? That's why we have to do this full and timely disclosure. Again, at the time that we're ready to make an offer. Don't wait until closing. Don't wait until afterwards and go, woohoo, I got a bonus. That's not full and timely disclosure. There's a couple restrictions on what we have to disclose with our compensation. First off, I don't have to disclose my commission to customers. Only clients get full disclosure. And the other restriction on my compensation is the split that I get from my firm. All we have to disclose is how much the firm expects to collect. How much I get of that ain't nobody's business. So I don't have to disclose my split. All we disclose is how much is the firm going to collect. Everybody with me? The real estate commission doesn't get involved with commission. Commission doesn't get involved with commission. If you're not happy with the split you get from your firm, do not call the North Carolina Real Estate Commission. They can't help you. If you're not happy with your compensation split, find another firm. Find a firm that you are happy. Once again, I hope you guys are planning on, if you haven't already, I hope you guys are planning on talking to several different firms so you can kind of have a side-by-side compensation split. They're all different.
Julie, I have a question.
Yeah.
Let's say you're going with ABC Realty, okay? And their commission split is whatever it is, okay?
Okay.
If I didn't like, would all of the ABC's realties in different towns be the same split? Or
Maybe.
is it different per building?
It could be different per location. It could be different per production of the agent. You might have a top producer that has a
Okay.
higher split than a brand new agent. It's all up to the firm's policy.
You're frozen.
You guys here? We here? We're here? Okay. It's all up to the firm's policy. They can offer whatever compensation split they want to. You don't have to agree to it if you don't like it. You can find a firm that you do, which is again why I want you guys to shop around. They're all different. Question comes in about how we document that we disclose compensation information before presenting the offer. Follow it up with an email, you guys. If you have these conversations face to face or on the phone, as soon as you hang up or as soon as you get home, send an email or send a text talking about per our conversation. If you buy this house, I get a $500 bonus. and then save that email. It's twofold, right? It doesn't do you any good if you don't save it. We talked about unlicensed persons live class, how we can compensate an unlicensed person. The big thing about unlicensed employees, they cannot be paid a per transaction basis. They are paid hourly or salary. If you hire an unlicensed person to do a job for you, if you hire them for 10 hours a week, you pay them for 10 hours a week. You cannot give them a bonus when you've had a closing. Remember our funnel? Transfer of real property for others for compensation requires a license. And in all this discussion about bonuses and incentives and referrals and rebates and all that, remember RESPA rules. What's RESPA? Real Estate Settlement Procedures Act, Unit 21. Write that down if you've never heard that before. RESPA is in Unit 21. RESPA of several things. RESPA says that settlement service providers can't give or receive anything in exchange for recommending services. So if RESPA, or if a lender's involved, remember, RESPA is the R in TRID. TRID is a lender law. So if it's a cash buyer, the rule is there are no rules. RESPA is not around. It's a lender law. RESPA says I cannot receive $1. I cannot receive a donut for recommending a settlement service providers. You and I are settlement service provider, the attorney, the home inspector, the pest inspector, the lender, the surveyor. Questions? Okay. Let's take a break. Take 10, we'll come back, keep going to license law and commission rule. My alarm sounds funny today. We got the message there, right? All right, we are back. So I am going to take attendance. We're going to jump back in. Okay, so compensation. Switching gears again just a bit, still on commission rule. We talked about the broker in charge last class. Remember we said each firm, let me rephrase that, each office location has to have a designated broker in charge. Each office location. If your firm has 4 office locations, how many BICs do you need? You need 4. You got to have a BIC under each roof. Everybody with me so far? How do you become the designated broker in charge? We talked about to become the designated broker in charge, you have to become BIC eligible. I think we'll see that again in just a second. So 1 BIC under each roof. The BIC cannot supervise more than 1 office. Thank you. Welcome back. Thank you. So this leads us into the conversation. At some point in your career, you may want to open your own firm. Is that in anybody's plans? Is that in anybody's long-term plan? A couple of you open your own firm. Well, understand you're, a little ways away from that. And once you open your own firm, once you decide to open your own firm, you have some choices. You can either get your license or get your firm licensed. The firm has to have a license and you have to have a license. You could designate yourself as the broker in charge of your own firm. So you can get your firm license, start your own LLC, S Corp, whatever. You'll learn more about that in post-licensing. And then, assuming you're BIC eligible, you can designate yourself as a broker in charge. Your other, or let me say, another option could be to become a sole proprietor. A sole proprietor is not a firm. A sole proprietor says how many people are operating, under this sole proprietorship? Just 1. So you're a one-man show. Understand there's some limitations to being a sole proprietor. If you plan on maintaining a trust account, you have got to get your firm licensed and you've got to get a designated broker in charge. If you plan to, I'm going to come back to that second one because that's a discussion. If you plan to have another broker affiliated with you, you've got to get your firm license and have a broker in charge. If you plan to advertise your services, you've got to get your firm licensed and have a designated broker in charge. Advertising your services in any way requires you to get your firm licensed and to have a designated broker in charge. So let's say you're a sole proprietor. How the heck are you making money? Referral fees. You can refer business out. You can do business with those that should reasonably know that you have a real estate license. Remember, you can't advertise your services. So who reasonably knows you have a real estate license? Mom, dad, significant other, family, bestie, right? All these people that are supporting you right now getting through this class, that's your source, that's your center of influence. So it depends on what kind of business you want. Again, if you want to be a referring agent only, you may want to consider sole proprietorship. If you want your own business to run out and have listings and work with buyers, and you plan to promote and advertise, and maybe one day you're going to bring somebody else on board, you got to get your firm licensed, and you have to get a designated broker in charge. You don't have to be the designated broker in charge, but you got to get one. So any of these activities will require a firm license and a designated BIC. So can you be a sole proprietor? Yes, as long as you don't do any of these things. Do I have everybody? What questions do I have on this? This is my retirement plan. You know, I'm getting the place down at the beach, and I'm going to go as a sole proprietor because I'm just going to do referral business. And walk out to my mailbox and get my check a couple times a month. That's my plan. We'll see how that works out for me, but that's my plan. Goals. We mentioned to be the designated BIC, you first have to be BIC eligible. What we talked about the other day, how you become, that's right. How you become BIC eligible. Well, this is what I mean by you guys are away. You have to have an active license. As a BIC, you can't be a provisional broker. Doesn't that make sense? You got to have some experience to be BIC eligible. At least 2 years full-time within the last 5 years, or 4 years part-time within the last 5 years. I do not know how they determine full-time and part-time. I don't know the answer to that. And then there's a 12-hour BIC course, broker in charge course. So once you do these 3 things, submit your form, then you're BIC eligible. Once you're BIC eligible, you're positioned to become the designated broker in charge. Some agents will become BIC eligible, never plan on being the designated BIC. You don't have to become the designated BIC to become BIC eligible. You could ride as a BIC eligible. I know a lot of firms like to have a couple BIC eligibles laying around just in case. You know, what if your designated BIC decides they don't want to show up for work today and you never see him again? What do you think happens to the firm license if the designated BIC quits? Yeah, it's a bad day, isn't it? The firm goes inactive. If the firm goes inactive, how does that affect everybody else in the firm? That's a bad day. So I know a lot of firms like having a couple BIC eligibles laying around. Things happen. I mean, heaven forbid, what if you're BIC? What if he's in a bad car accident? Once you're BIC eligible, you maintain your eligibility. You got to renew your license every year. We're going to talk about license renewal in just a bit. Bear with me. You got to renew it each year, and you got to keep your license on active status. We will talk about how we renew. We will talk about how you keep that license on active status. You can have only one designated BIC. Yep, each firm or office, say office. That's what you meant, right? Each office can only have one designated BIC. What happens if you lose? Shall I start over? What happens if you lose your BIC eligibility? Look at me go. If you lose your BIC eligibility, then you got to take that 12-hour BIC course again, and you got to reapply. So if you don't renew your license, if you don't do your CE, you lose your BIC eligibility status, and then you pretty much got to start all over.
I have a question, Julie. So let's say I was a BIC for a firm, okay? And I needed to leave and go out for surgery. And I was going to be gone for 2 months. My firm can appoint another BIC that's maybe off on the sidelines.
BIC eligible, yeah, as long as you're BIC eligible.
Right. So what happens to me then? Because it says
What
that you can
what do you
only
think
have,
that, what do you think that depends on? What do you think that's up to?
your firm.
There you go. Firm's policy. Yep.
If you have somebody that's BIC eligible and something like that happens, how long does it take for the firm to get that person in place?
It's a form you submit today.
Oh, okay.
It's all electronic now.
Okay.
Thank you, technology. Yep. Okay. Switching gears one more time. We've seen this a couple times. I hope when I flip this slide, you guys kind of roll your eyes and say, my God, Julie, I got it. I cannot draft legal instruments. I cannot draft legally binding documents. I cannot act like an attorney. I cannot draft. I cannot offer legal advice. Y'all, when your unmarried buyers look at you and say, how should I take title? Do not whip out your pre-licensing book and begin to explain joint tenancy and common to them. Telling somebody how to take title is offering legal advice. What are we going to have them do if they want to know how to take title? We're going to have them call their attorney, call the closing attorney. They can explain it to them. We cannot offer legal advice. And guys, there's a reason we keep drilling or trying to drill this in. Buyers and sellers ask. Y'all, please understand, it's not my buyers and sellers' job to understand the parameter of my job. It's my job to understand the parameters of my job. Everybody with me? So when your buyer calls you and says, how should I, what should I, give me legal advice, draft this document, draft this pre-printed version. I'm sorry, y'all, Old Car says I follow my clients' lawful instructions. We are not attorneys. We cannot act like an attorney. All I'm allowed to do is fill in the blanks of the pre-printed forms that have been created by an attorney. All the forms I use have been created by an attorney, and all I'm allowed to do is fill in the blanks. I think another misconception is that we can only use the NCAR forms, North Carolina Association of Realtors. We looked at, for example, our standard form 2T back in unit 10. That's not true. I can use any pre-printed form. I can use any pre-printed contract, we should say, as long as it was drafted by an attorney and it meets certain commission rules. Pay no attention to that page number. I should have taken that out. Don't pay attention to the page number. You guys don't need to know about this rule right now. You're actually going to talk more about this in post-licensing. Right now, what you need to know is there's a commission rule that exists that says if we're using an attorney drafted pre-printed form, it's got to meet these certain conditions. And that's what's spelled out in Commission Rule A.0112. Please, please do not think that we can only provide the forms or use the forms provided to us by NCAR. Again, let's talk about builders. It's not uncommon for builders to have their own sales contracts. Are you going to tell your buyer you can't assist them because the builder's form is in an NCAR form? I kind of hope not. You just cut yourself out a deal on a commission. Questions on this? There's another commission rule on reporting criminal convictions. So we all know to get your license, you have to submit an application, you got to do a background check. Once you are licensed, if you get yourself in trouble with the law, then we need to report this to the real estate commission. So let's talk about this first. Once you're licensed, if you've been convicted of a felony or a misdemeanor, I need everybody to note the word convicted. Does that say charged? Does that say accused of? What does that say? That says convicted. When the gavel comes down and the judge says guilty, you've been convicted. And if it's a conviction of a felony or a misdemeanor, once you're licensed, you have got to report that conviction to the commission within 60 days. What are they going to do to you? I don't really know. It's a case by case basis. Bottom line, I think it's going to come down to how badly did you harm the public? If you are convicted for stealing money, how do you think the real estate commission is going to feel about that? Letting you run around with earnest money, due diligence fees. You guys with me? So just because you get yourself convicted doesn't mean you're automatically going to get in trouble with the real estate commission. This is what I do know though. Failure to report it will get you in trouble with the real estate commission. I don't know what kind of household you guys grew up in, but in my household, it was best when you did something bad, it was best that you fess up to mama instead of letting mama find out on her own. Anybody else in a similar home? Don't let mama find out. Think of the commission as mama. Don't let them find out on their own. When they do find out on their own, you will get in trouble because this is a commission rule. So are you going to get in trouble for the conviction? I don't know. But you will get in trouble if you don't report it within 60 days. The second piece of this is if you've received disciplinary action from another occupational license. Do you have another occupational CPA, CNA, for example? If you get yourself in trouble with that licensing board, you've got to report it to the real estate commission within 60 days. Again, what are they going to do to you? I have no idea. What are they going to do if you don't report it? Now you're facing disciplinary action because you violated a commission rule. This has come up a lot in the last year or so. I've seen this a lot in the disciplinary action they send out. Broker failed to report their conviction. Is anybody planning on getting a real estate license in another state? Maybe South Carolina, Virginia. I got a couple of you on the border that are really close. That other license, if you get a South Carolina real estate license, that other license falls under this occupational licensing board. So if you get yourself in trouble with the South Carolina Real Estate Commission, you have to report that to the North Carolina Real Estate Commission within 60 days. Questions on this? Commission rule regulates our seller disclosures. We talked about the RPODs, Residential Property and Owners Association Disclosure Statement, and the MOG, Mineral and Oil and Gas Rights. This was a Unit 8 discussion. These forms are seller disclosures. So who completes these forms? Who completes them? The seller. That's why they're seller disclosures. Can I provide the form to my seller to complete? Sure. Can I assist them in completing it? Of course. What I can't take the pen is take the pen and say, oh my God, let me just do this for you. They have a duty to complete this form. That's why they're seller disclosures. We remember we learned some Latin, something called caveat emptor. Buyer beware. Caveat emptor says, what does the seller have to disclose? What does the seller have to disclose? Nothing. They don't have to disclose, they don't have to fix, they don't have to repair. These forms give the option, the seller the option to say, yes, there's a problem, a known problem with the home or the property. No, there's not a known problem with the home, or no representation. I'm not saying yes or no. The seller doesn't have to disclose. The only thing they can't do is lie. They cannot lie. If they're answering yes or no, they have to do so truthfully. If there are any changes to the property condition while we have it listed, we need to get with our seller to do an updated form. So let's say they say, no, the roof doesn't leak. And then we get a day like today. And after today, the roof leaks. We got to get with the seller to update the RPODs. So if it's broke and then was fixed, or if it works and then broke, we need to keep these forms current, particularly the RPODs, throughout the listing. Can I make anybody do anything? Not that I figured out how yet. What if your seller refuses to do it? Can I make them do it? Can I just do it for them because it's easier that way? Nope. We have a duty to explain to the seller, fine, you don't want to do it. This could be an out for a buyer. Failure to receive the seller disclosure could give the buyer an out. Anybody remember how many days the buyer has to terminate because of this? Blow my socks off. Anybody remember? You can show me on your hand. Few too many. 3. Yep, 3. So if the buyer hasn't received these forms, they have 3 days. They can cancel, they can terminate. They'll get their earnest money back, they'll get their due diligence back, they can rescind their contract. So use this as a carrot with your sellers, you guys. If they don't want to do it, say, well, you could lose the buyer. I know in this market, we're thinking, oh, well, what's the big deal? But guys, I'm telling you, we're seeing the market shift daily. We are coming back into a buyer's market. They will be in the driver's seat again. So if your seller waited 6 months for a decent offer, not good, decent, do we want to risk losing that buyer? Probably not. Don't give them an out. So Unit 8, seller disclosures. Yeah.
If there is something that needs to be updated, like the roof is leaking, that is an amendment to the original contract, right?
I'm not following you.
Like if it does need to be updated, if they completed these and then something does happen and they need to change it later
We're
on.
just going to do a whole new form. Yeah, I got you. We're just going to do a new form. We're not going to try to, because that form is, I mean, it's like a font 6, I think. So it's just so much easier just to, you know, I don't know what the commission rule says on that, but yeah, just do a new form.
Okay.
And that way there's no confusion.
Gotcha. Thanks.
Are you going to keep the old one? Yep. Category of everything. Thank you. Commission rule tells us that we have a duty to review these closing disclosure statements. Unit 21 is all about closing disclosures. What's a debit to the seller? What's a credit to the seller? What's a debit to the buyer? What's a credit to the buyer? So we have a duty to make sure that our clients receive a closing disclosure. But our bigger duty is to make sure that we review it for accuracy, review things that we should reasonably know. Don't I know the sales price and the due diligence fee and the earnest money deposit and any seller paid closing costs? Isn't all that hashed out in the sales contract? So when you go to review these things, the first thing you do is pull out your contract, any amendments to the contract. Don't we now know how to prorate property taxes? Don't we know how to calculate interim interest? These are things that we can verify. We can review for accuracy. When you find a mistake, I didn't say if, When you find a mistake, we've got a duty to notify the parties, i.e. the lender and the closing attorney. Guys, humans prepare these things and humans make mistakes. And the thinking behind this is the more sets of eyes we have on it, the better chance for accuracy we got. You can't get shy on me now. Oh, well, it's only a couple $1,000s. It won't matter. I'm too ashamed to call the attorney's office. What kind of service did you just offer to your client? Did I tell y'all about the one I reviewed and my commission was missing? Did I tell y'all about that? Is that important? If that doesn't make you review these things, then I don't know what will. So we have a duty to review these things for accuracy. Again, closing disclosure, everything we need to know about that is Unit 21. Any questions? So we're going to switch gears again, just one more time. And this discussion is about the trust account, the escrow account. Again, one of these things we've danced around the whole class, but now we're going to have our specific conversations. There's a lot more information about the trust account and the escrow account that we're going to go over, but rest assured we're covering what the commission says you may need to know for your test. I also think it's important that we recognize that the trust account or the escrow account is covered under both license law, which is North Carolina general statute, and commission rule. There's not a lot that's covered under both, but the trust account is. So first off, let's start with defining what a trust account is. A trust account is one that has somebody else's money in it. Your money does not belong in the trust account. Real estate firms that have a trust account also have an operating account. Operating account is what you pay your bills, what you receive commission checks into. So a trust account, the basic definition, it's an account with somebody else's money. In a private chat, and think before you answer, what are some examples of monies that would belong in your firm's trust account? What are some monies? When would I want to hold somebody else's money? In a real estate transaction. So one of the big ones that I'm seeing, and I agree with you guys completely, is the earnest money deposit. Remember, the earnest money deposit is the buyer's good faith. Commission rule, license law and commission rule. So earnest money is showing the buyer's good faith. When we go under contract, the buyer writes a check for the earnest money deposit to the escrow agent, and the escrow agent, they're just the impartial third party that's handling it, holding it for safekeeping. If you were buying my house, would you trust me to hold your earnest money deposit? Not me personally, I know you guys trust me, but what if I were just any seller? Would you trust? So buyers and sellers don't know each other, you guys. So how can we assure that the seller doesn't run away with this money? We put it in this impartial trust account. We allow a third party that has no interest in this transaction. We allow a third party to handle it. Another really good example I saw was your security deposit. Per the guidelines of the Tenant Security Deposit Act, security deposits either go in the trust account or a bond if you're unlicensed. Once you're licensed, your only option is to put it in a trust account. If you're a property manager, you may want to run rent so you can pay all the parties through the trust account. Rent comes in from the tenant. One thing I saw from several chats that we need to have a conversation about. due diligence does not belong in the trust account. Who gets that due diligence fee? Who gets it? Yep. The seller gets the due diligence. The buyer pays the seller directly. There's no need to put it in a trust account. The buyer pays the seller. So again, the only purpose that we have it for a trust account is to hold somebody else's money. Everybody good with me so far? We're keeping it safe. There's some, can we stay on topic right now? Happy to answer that later. Let's focus on trust accounts. Let me say this, some real estate firms have a trust account. If the firm you join doesn't have a trust account, then the closing attorney will have a trust account. And what I'm noticing is a lot of firms, real estate firms, are doing away with the trust account and letting the attorney handle it. They have to have one anyway. And trust accounts are just usually a pretty big liability. I see this a lot in the disciplinary action too. So what firms are saying is, you know what, let's just put this on the attorney. So it doesn't matter who has it, but whomever has the trust account, there's three primary features. There's three primary things we need to understand. First off, and most importantly, the trust account is separate. It's not your operating account. Again, if your firm has a trust account, they actually have two accounts. They have one to pay their bills and one to hold somebody else's money. It's a separate account. You would have to, that's right. The sole proprietor can't have a trust account. The trust account is custodial, which means the people that have access to it is limited. And the people that have access to it don't have money in it. Again, basic definition of a trust account is it's an account with somebody else's money. Your money doesn't belong. And then the trust account, the money in the trust account needs to be available on demand. Let's say your firm has a bad day and every single one of your buyers terminate their contracts today. That's a bad day, y'all. Go out and have a drink after work, all right? You deserved it. Bad day. If every single one of your buyers terminate their contract today, we need to have that money available to send it to the appropriate party, may it be the buyer or the seller. You can't say, well, let me get paid on Friday and then I'll reimburse you. It's got to be on demand. You're only using it as a holding ground. So the funds can be withdrawn at any time without any notice. You're not spending this money, you're holding this money. As we said, it needs to be a demand deposit account. Money's in demand, it's available. It's got to be in an FDIC bank. A lot of credit unions, for example, are not FDIC. So before you run out and open a trust account, well, there's a trust account course that you have to take through the commission. And one thing they're going to tell you is the bank's got to be FDIC. It's got to be lawfully doing business in North Carolina. It does not need to be physically located in North Carolina, but it needs to be lawfully doing business in North Carolina. And you and the bank agree to make the account available for inspection. If the real estate commission walks in the door and says, show me your trust account books. Oh, hang on, let me balance it real quick. I'll be back to you. No, if the commission walks in the door and says, show me your books, you have to be able to say, okay, it's got to be ready for inspection at any time by the commission. I mentioned earlier, there's a trust account course. So my landlords, you may want to consider looking into that. You can find that information at the commission's website. It tells you how the commission expects you to maintain that trust account. The words trust account or escrow account have to be on everything. Deposit slips, checks, bank statements. It's got to be clear that it's a trust account or an escrow account. And here's the reason why. What if you're a one-man show? You're a broker in charge of your own firm. You have a one-man show and that man dies. We can't have somebody else's money wrapped up in the estate. So by clearly identifying this is a trust account or an escrow account, what we're saying is that this isn't my money. This isn't up to the will. This is somebody else's money. I'm going to stick to the topic. We need to have accurate records. You need to show money coming in, money going out, deposits, checks being written. Back in my administrative days, even before I was licensed, I was doing the trust account for my office. I was keeping up with it every day. It was accurate. Once a month, I got the bank statement. I sat down and balanced it. Got to go to Raleigh and take a class because it's just so long ago. They weren't offering it online yet. So I got to go to Raleigh, take a trust account class. It's as exciting as it sounds. If you're holding somebody else's money, you only need one trust account. For example, there's some firms that may do for sale and for rent. So they may have earnest money and security deposits. They only need one trust account. You can choose to have more than one, but you only need one trust account. The exception to this rule is if you're a property manager and you're managing more than one HOA. If you're managing more than one owners association, each owners association needs their own trust account. So if you're a property manager and you're managing for rent, you have security deposits, you're managing an HOA, you have a separate account. Does that make sense? If you're managing 5 HOAs, you need 5 trust accounts. Hands down, the #1 violation in trust accounts is commingling. Commingling is putting your money in the trust account. Your money doesn't belong in the trust account. Your trust account has somebody else's money. You can't take somebody else's money and put it in your operating account. You can't take your money and put it in your trust account. What if the city calls you today and says, you haven't paid your power bill? If you don't pay it by 5 p.m., we're going to cut off your power. Y'all, it's like 38 degrees out there. It is cold. Are we appreciative of heat this morning? I sure am. So let's say you get that call. They're going to cut your power off at 5 p.m. and you don't get paid till Friday. Well, I think I can borrow a little bit of money from the trust account to pay my power bill, but it's okay because as soon as I get paid on Friday, I'll replenish it. I'll put it back in. Thank you guys for shaking your heads. No. That's commingling. You can't borrow somebody else's money. Everybody with me? #1 violation. When you guys start getting this disciplinary action, you got a violation of trust account, it's going to say commingling. Don't we love these rules with all these exceptions? The exception to this rule, if your bank charges a monthly fee, you can have no more than $100 at a time of your money in the trust account for the sole purpose of covering that fee. So if they're going to do an automatic draft of $6 a month or whatever, you have money, you have up to no more than $100 of your own money in there to cover that fee. When that goes away, you can replenish it. Again, no more than $100 at a time, just to cover bank fees. Trust accounts can be interest bearing as long as the parties agree. Our standard offer to purchase and contract says the trust account can be an interest bearing account. The interest belongs to the owner of the trust account. So they collect interest every month and then they transfer it from their trust account to their operating account. The designated broker in charge is responsible for the trust account. Remember, I told you guys just a few minutes ago, back in my admin unlicensed days, I maintained it. I was in there every single day. Was I responsible for it? No. If the commission walked in the front door, y'all, they're not asking for Julie. They were asking for my broker in charge. I sat down with him once a month and reviewed the trust account with him per his request, because he knew he was responsible. And I tell y'all, if I couldn't get that thing, he said, don't come see me if you don't get this to balance. I remember one month I was off by like 12 cents. Y'all talk about banging your head on the desk. I was ready to put, can I just put my own, can I just give you 12 cents and we can deposit? And he said, no, Julie, we can't do that. I figured it out. Dang it. I figured it out. He didn't want to touch it though until it was balanced, because he's not signing off on it until it's balanced, because he, the BIC, was responsible for it. Records have to be current and accurate. There's no specifics about this, but you know what? The bank statement comes out once a month. So what a better time to sit down and reconcile. Again, if the commission walks in the door, they need to be up to date. They need to be current. Commission rule delegates how we disperse the earnest money from the trust account. Commission rule says that we cannot disperse earnest money from the trust account no more than 10 days prior to settlement. So if your firm holds the earnest money and you know you have a closing coming up, somehow you have to request that earnest money from your firm so you can take it to closing. Your firm may have regulations on how they want that handled. But what the commission says is we cannot disperse it more than 10 days prior to settlement. The commission also gives us a disputed funds rule. Remember, you guys, the escrow agent is just holding it. I am in no way a party to this contract. I'm the impartial third party that is holding this earnest money. So what if the contract terminates? If we're within due diligence, the buyer should get it back. If we're outside of due diligence, the seller should get it. However, it has to be released by the parties. Just because it's in the contract, that's what happens. We still have to have everybody release it by signing off on it. If buyer or seller don't release it, then it's a disputed funds. When it's a disputed funds, the escrow agent can't release it unless they have permission by both parties. Even though that's what the contract says. It's not my money to decide what to do with. If the escrow agent can't get permission by both parties, they could try, send some certified mails. But eventually, their only other option is to release this money to the clerk of courts and let the two go downtown and hash it out. The escrow agent cannot make the decision about what happens. So the story I started a few minutes ago when we were talking about retention of records. First off, why don't you guys remind me, how long do we keep our records? How long do we keep everything? Keep everything, that's right. Yep, I see some hands going up. At least 3 years. And what that retention of records rule says, is that the 3-year clock starts at the successful or the unsuccessful conclusion of the transaction. So let's say you're the listing firm and you're holding the earnest money and the buyer terminates and the earnest money is in dispute. Can I read the contract and say, well, it says right here, if you terminate, this says who should get it. So I'm just going to go ahead and take it upon myself and release it. Can I do that? No, I got to have permission by both parties, not my money to decide what to do with. Everybody with me? So this money's in dispute. Let's say that 2 months, we terminate, and then 2 months from now, we finally get permission to release it. Isn't the conclusion of that transaction two months from now when we release the earnest money? We need to look at that timeline. It's not just when it terminates. There may be some other activities that need to be done before it's concluded. And in the example of disputed earnest money, your 3-year clock doesn't start until we've decided what we're going to do with that earnest money. Are we going to release it? Or are we going to turn it over to the clerk of courts? So that's a little story I decided to wait till right now to tell you guys. Disbursement just means dispersing it from the listing firm to the closing attorney. We got to get it to the attorney for closing because that's part of the buyer's money, right? That's money that they put down. So we have to have that money accounted for. So that's what we mean by, thank you. That's what we mean by disbursement. Any other questions on this disbursement and disputed funds? Again, this slide is particularly about earnest money. Tenant Security Deposit Act doesn't cover disputed security deposits. That's why we say that. This is just about earnest money. We have some law and rule. It says we have to deposit it within 3 banking days of receipt or contract formation. What do I mean by that? Okay. We negotiate the offer and we go under contract. Yay. The buyer does not owe any money until the contract's been formed. If the contract's never formed, the buyer doesn't owe money. Contract is formed. Bear with me, please. Contract is formed. You receive the earnest money deposit. You now have 3 days to get it in the bank, 3 banking days to get it in the bank. Okay, so we form a contract today. Maybe you don't get the earnest money until tomorrow. That's why it says of receipt. Okay, so your 3-day clock starts when you receive it. What if there are cases where your buyer may hand you earnest money while you're still negotiating the offer? You're in the throes of negotiations and your buyer may say, hang on to this earnest money deposit for me. We're not going to deposit it until and if a contract is formed. So in this case, it wouldn't be 3 days of receipt. It would be 3 days of contract formation. So you receive it today, a contract is formed tomorrow, that's when your 3-day clock starts. So that's what we mean by receipt or contract formation.
Okay, I have a question.
Please.
So, because this one right here, like I get it for the most part until these questions come at me and slowing down trying to read these questions. So this one right here has been a thorn in my side. The receipt or the contract. In a test question, you have both as a question, as an answer.
So do yourself a timeline and see which one. You're not going to deposit it until you're under contract.
Okay, so maybe that's where I missed it, because when in a receipt, you have 3 days. If you're not in the contract or you don't have a receipt, you're just holding on to it until either one of those?
Until a contract is formed.
So you're not depositing it?
Not until a contract is formed.
Okay.
The buyer doesn't owe any money until the contract is formed. You good with me so far? So if the contract's never formed, buyer says, here's my earnest money deposit, hang on to this for me. Okay, I'll hang on to this for you. Don't run out and deposit it because the buyer doesn't owe it. So we're going to hang on to it per their request. I'll talk about that in a second. So we're going to hang on to it per their request. We have it for a day, 2 days, a week, however long it takes us to form the contract. So in that case, it's 3 days from contract formation because I already have it, but I'm not going to deposit it until a contract is formed. If you don't receive it while you're negotiating, the contract is formed, then you receive it, you have 3 days from receipt. So yes, you're going to see different scenarios. And that's why we need to understand receipt of the earnest money or contract formation. You guys know me, I like pictures, right? Draw it out. You get a receipt. We're not under contract yet, so don't start counting yet. We go into contract, 1, 2, 3. You go under contract and then you receive it, 1, 2, 3. There's 2 different scenarios there.
Can I ask one more question? This
Please.
may be stupid to some of y'all, but
No?
okay, so banking days,
Yes.
business days,
Banking
We're-
days.
totally different things, right? Banking days and business days. The Saturday is still a,
Bank,
okay. I just
banking
wanted to
days.
clarify that.
Contract forms, I'm going to get there in just a second as well. Bear with me. I'm getting there. The exception to this rule is cash. As soon as they give you cash, get that thing in the bank. Cash walks away easily. So the best way that we can protect cash is just to deposit it. And I mean, commission rule, I said as soon as, listen to the real estate commission, not Julie. Commission rule says 3 days from receipt for cash, whether you're offering in the throes of negotiations or not. So whenever you get cash, you always have 3 days. If you're in the throes of negotiations and the buyer hands you cash, we can deposit it. If that contract's never formed, that's readily available funds. I don't have to wait for that check to clear the bank, right? I can get it back to him right away. So the safest place for cash is in that trust account. If the contract's formed, it's already there. You guys, as provisional brokers, cannot walk around with somebody else's money. A provisional broker cannot walk around with somebody else's money. A full broker should not walk around with somebody else's money. As a provisional broker, if your buyer hands you an earnest money deposit, you're in the throes of negotiations, and your buyer hands you an earnest money deposit, says, hang on to this for me while we're negotiating, you've got to turn it over to your BIC. Bottom line, you guys, when somebody else's money is in your hands, it is your responsibility. And as a provisional broker with training wheels, the commission doesn't feel that you're ready for that responsibility yet. So as a provisional broker, when your buyer hands you, throws in negotiations, and your buyer hands you an earnest money check and says, can you just hang on to this for me until we work this out? Run, don't walk to your broker in charge. Get it to your BIC, let them be responsible for it, let them hang on to it. Commission rule also regulates how we handle option money for an option contract or due diligence fee. In these cases, we're just acting as courier. We're delivering from the buyer to the seller with a couple agents in between. Buyer usually gives the due diligence to the buyer's agent delivers it to the listing agent delivers it to the seller. We have to deliver it no more than 3 days following our receipt. So whenever you get that check in your hand, you have 3 days to get it to where it needs to go. So let's say you are a buyer's agent and you just got your buyer under contract. Mini celebration. And you tell your buyer, congratulations, you're under contract. Now that we're under contract, I need to meet with you to get 2 checks. So you meet with your buyer somewhere to get the due diligence check and the earnest money check. You tell your buyers who to make them out to, how much, go to the bank, cashier, write a check, whatever. So you meet your buyer and you get those checks. And you are in your car delivering those checks to the listing agent. You still have those checks in your hand. Your buyer calls you and says, don't deliver it. Do not deliver that to the seller. Guys, it's not my money. I need to follow my buyer's instructions. So if they call you, it's still in your possession, and they call you and say, do not deliver that. And you can say, are you sure? The seller will probably terminate. They might be able to sue you for this money. Are you sure? No, do not deliver this money. I've got to follow their instructions. I'll say this again. It's not my money to decide what to do with. I'm simply acting as the courier. I'm driving it from point A to point B. Everybody with me? It's my responsibility when it's in my hand, but that doesn't make it my money. So when your buyer says, don't you deliver that money, we have to follow their instructions. Questions on that? I got one more thing to say about the trust account. I'm watching my time, trust me. Got one more thing to say about trust account, and then we're going to take a break. Questions on that? Follow their instructions. Once it leaves your hands, it's out of your control, right? So once the listing agent gets it, might as well just give it to the seller. So when it's in your, it's never happened to me, but obviously it happens often enough that there's a commission rule on it, right? I don't know how often it happens, but there's a commission rule about it. So okay, last thing I have to say, which is something we've already said, we are all responsible for safeguarding monies. When that money is in your hand, you're responsible for it. My suggestion to you is to get it from point A to point B. Get it to where it needs to go. It doesn't matter if your firm has a trust account or not. Again, you guys, a lot of real estate sales firms are doing away with the trust account. We're letting our closing attorney handle that. If you're property management though, you got to have a trust account because you got security deposits. So a lot of real estate sales firms, and guess what? It doesn't matter. Isn't this kind of an old car? If you trust me to deliver and play courier for your money, then I'm going to be responsible for it. And I'm going to get it to where it needs to go. Questions? Let's take 2. We back? Y'all seeing that light at the end of the tunnel? It's there. One of my dadisms, I'll say it. He always says, it's good when you know the light at the end of the tunnel isn't a train. So I think you guys are seeing light, but I do not think it's a train. All right, let's take attendance. Is there like a dad school you guys go to learn these things or something? Where do you get this stuff? So let's take attendance. The last little thing in this comment section, this starts on page 106. And then we need to go back and get a few other things, pick up a few other things. But the last little thing in this comments section is about BPOs and CMAs that we talked about in Unit 17. Again, BPOs and CMAs are one of the rare things that's covered under both license law and commission rule. So we got both North Carolina General Statute and we got Real Estate Commission rule. Provisional brokers cannot do a BPO or CMA for a fee. I don't have that available right now. And I don't know if I'll have time to do it. So provisional brokers cannot perform for a fee. You can do a CMA or BPO, but as a provisional broker, you cannot charge a fee. Nobody can charge a fee when doing a BPO or CMA as part of our job. Just general brokerage when you're working with sellers or buyers. We're not gonna nickel and dime them to death. They're paying you commission to offer them brokerage services. Remember, we as agents do not get to determine value. Y'all go ahead and take the word value out of your vocabulary. The appraiser is the one that gives their opinion of value. What do? We determine probable sales price or probable lease price. If as a full broker, you're doing a BPO or CMA for a fee, you got to make sure it's in compliance with license law and commission rule. Good. So if you're performing for a fee, it's got to be within license law and commission rule. We'll get into license law and commission rule more in post licensing. So we'll dig a little deeper. And then anytime you perform a BPO or CMA, it's got to be in writing. Questions on BPO CMAs, Unit 17. So we do the CMA to help our sellers determine what to list it for. We do a CMA to help our buyers when they say, this is really nice, how much should I offer? The appraiser is determining estimated value, their opinion of value for the lender for the purposes of originating a mortgage. So we're two different people. We're doing something similar, but at the end of the day, we're two different people doing two different things for two different purposes. Yep. All right, so this is the end of this section in the end, the one that I really asked you guys to focus on. This is where the bulk of this material is from. We do need to go back throughout the booklet and get other information, pick up other information, both in license law and commission rule. Once again, I've provided you page numbers. Guys, we're not focused today. And I know it's the last day of class and we're like, all over the place. I'm happy to answer any question off topic after class, but Can we please focus? Because this is still testable stuff. So the page numbers that you see, again, refer to the page numbers in License Law and Commission Rule Booklet. Okay. So we need to go back and talk about proof of license. Once you guys get a license, they'll mail you a nice 8.5 by 11. This is your goal right here. Doesn't that look nice? Envision this on a frame on your wall somewhere. I hang this thing with pride because you know what? I worked hard for this thing. And I look at it and say, dang it, I did that. You guys do the same. So go get you a nice frame for your 8.5 by 11. In addition to that, each year that you renew your license, you will get a pocket card. Maybe it's a piece of paper you can cut out and put in your wallet or your pocket. You can also get a digital pocket card on your phone. So we have to renew our license every year. I'll talk about that in a second. And each year that we renew, we have to carry around our current pocket card. That's our proof of licensure. So you don't have to carry this thing around with you. You just got to carry your pocket card, your digital card. Isn't that handy? We need a big purse for this, wouldn't we? All right, so we got our pocket card, our digital card. Again, all real estate firms are licensed. It's a separate firm license, is a separate license. All the firms have to display their license. All firms' license need to be displayed. Back to the pocket card for a second, my apologies. They say anytime you're engaging in brokerage activities, you need to have proof of licensure on you. So if you're doing an open house, if you're attending CE, any agent activity. If I'm giving out a business card, that's a brokerage activity. So ladies, when you go on vacation and you transfer over your vacation purse, go ahead and grab that pocket card because you're on vacation down in Key West sitting at a bar and somebody says, oh, I thought about buying a house in North Carolina. Don't you want to be able to say, here's my business card. Just have it with you on all times. We cannot disclose the terms of the offer without the offeror's permission. Remind me in a private chat who's the offeror and do not say buyer or seller. Who is the offeror? Who is the offeror? Yep. The offeror is the giver of the offer, the creator of the offer, the person giving the offer. We cannot disclose the terms of the offer without permission of the offeror. Do you think any offeror in their right mind is going to give you permission to disclose the terms of their offer? No, that's called shopping offers. That's called pitting buyers against each other, pitting offerors against each other. So when you're the listing agent and you're starting to get multiple offers, you'll get a call from an agent that says, what's your highest offer? There's no rule that says that they can't ask. The rule regulates how we answer. And our answer is, I cannot disclose the terms of that. Tell your buyers to bring their highest and best offer. That's about all we can advise them to do. License renewal. I said our license expires each year. Technically, our license expires at midnight on June 30th every single year. The Real Estate Commission operates on a physical year. They do not operate on a calendar year. They operate on a physical year. And the real estate commission's fiscal year is July 1st to June 30th. Failure to pay your renewal fee by 11:59 p.m. on June 30th means at the stroke of midnight, your license has expired. The renewal period, the time that we have to pay the fee, is May 15th to June 30th every single year. We all have to renew our license May 15th to June 30th, 11:59 p.m. on June 30th. For last year and the last, I don't remember how many years, it's been $45. Of course, that's subject to change at direction of the Real Estate Commission. But for $45 each year, you can renew your license. When you renew your license, when you pay the fee, that makes your license status current. And when you guys see current, I want you to see the word currency. Your license is current because you paid the fee. Failure to pay the fee means your license is expired. This has nothing to do with education. I'm getting ready to talk about education. This has nothing to do with education. To have a current license, you pay the fee between May 15th and June 30th. 45 days to pay $45. Again, you just log on to your account, submit it, poof, you're current for another year. A current license can be one of two things. A current license can be active, or it can be inactive. So you're current, why? Because you showed them the money. You're current because you paid the fee. An active license means it's current and you are up to date on your education. This is for full brokers only. I'll bring PBs in just a second. So full brokers and broker in charges, non-provisional brokers. How do you maintain an active license? You pay the fee and you do CE. That kind of rhyme? Pay the fee and do CE. Pay the fee, keeps your license current. You do your CE. You have an active license. I'm going to talk more about CE in just a second. Two things. Pay the fee of $45. I'm going to talk about CE in just a second. You're going to pay the fee of $45 and you're going to do CE each year. That's all you have to do to have an active real estate license. Active is the only license category in which you can get paid. That does include referral fees. Active is also the only current status in which you can advertise or promote your services in any way. You can't even give out a business card if your license is not active. So it's active because it's current, which means you pay the fee and you've done your CE. An inactive license is also current. So who are the agents with an inactive license? Well, you guys without a BIC, without your training wheels. So the day you pass your state exam, congratulations. Here's your inactive license that you can't do anything with. Good job. As a PB, how do you affiliate or how do you activate? I just gave you the answer. You kidding me, Julie? As a PB, how do you activate? You affiliate. You sign on with a broker in charge. That gives you an active license as a PB. Failure to complete your CE or not do your post licensing on time means you have a deficiency in your education. So if you pay the fee, but you have a deficiency, your license is inactive. You pay the fee, so it's current, but you have a deficiency in your education, so your license is inactive. You could also choose to ride on an inactive license. Maybe some of you don't want to activate right away. Maybe years from now, something comes up in your life and you need to put real estate off to the side for a minute. You may want to choose to ride on an inactive license. All you got to do is pay the fee each year. Why would you do that? I will answer that in just 1 minute. Samantha, that is absolutely correct. Question comes in, what if you get your license on May 14th? When's your first renewal period? Tomorrow. So if you get your license on May 14th, you have to renew during May 15th to June 30th. So the date you guys get your license will have a date on it that tells you your date. Look at your first May 15th, and that's when you have to do pay your first renewal fee. So a current license can be active or inactive. The only thing we know by current is that you've shown them the money, you've paid the fee. How do you keep a current license active? Fee and CE. An inactive license can be reinstated. It depends on your CE deficiency. If you've been inactive, you've been paying the fee, you could also choose to keep doing CE. So if you do not have a CE deficiency, all you got to do is submit the form to reactivate. If you're inactive and you do have a CE deficiency, if it's less than 2 years, then you got to get caught up on some CE. So again, you can take CE with an inactive license. You always have to pay the fee. You're thinking of CE that I will talk about in just a minute. So if you're inactive for less than 2 years and you have a CE deficiency, that's what you need to get from this slide. They're going to make you get caught up on CE. Guys, please give me a minute. We're not talking about CE. We're talking about the renewal fee. You've got to pay the renewal fee every year. You don't have to do, you don't have to do CE your first year. You have to pay the renewal fee. If you're inactive for more than 2 years, you got more education to get caught up. Not only do you have to fulfill your CE deficiency, but you need to go back and take 2 post-licensing classes again. The thinking here is if you've been more than 2 years without any kind of education, you've lost a lot. So if you're inactive for more than 2 years, again, you're inactive because you've been paying the fee every year. It has nothing to do with education. A current license has nothing to do with education. Failure to pay the fee means your license is expired. Can you practice on an expired license? Can you get paid if your license is expired? Can you give out a business card if your license is expired? So the 2 main status, current or expired. Failure to pay the fee means at the stroke of midnight on July 1st, your license is expired. How do you reinstate an expired license? Well, again, it depends. If your license has been expired for less than 6 months, You pay the fee times 2. So $45 plus $45 means you pay $90. So you wake up on July 1st and go, oh my God, I cannot believe I forgot to pay that fee. It's okay. Pay the $90, submit your form, and poof, you're back in, assuming you're up to date on your education, assuming you did your CE. If you're expired for 6 months to 2 years, you pay the fees. You have to go back, take a post-licensing, or go back to PSI Testing Center and sit for the state exam again. I believe most of us would opt, based on the expressions on your face right now, I believe most of us would opt for a post-licensing class, but you have choices. So if you're expired for 6 months to 2 years, you wake up one day and decide you want to reinstate your license, pay the fees, and then you have a choice, post-licensing or PSI Testing Center. I need you guys to brace yourselves. Is everybody hanging on to something? If you're expired for more than 2 years and you want to reinstate, you get to start all over. So the $1 million question a few minutes ago was, why would I pay that $45 every year if I think I'm done with real estate? My answer to you is, I would love to see you guys in post-licensing. I'll bump into you in CE. Maybe we can even work a deal together. But once we get you through pre-licensing the first time, don't make yourself come back. Y'all, this happens a lot more than you think. People think they're done with real estate. They think they're done with real estate. So they let their license expire. I'm going to save $45 a year. And you let your license expire. And then you wake up one day and you go, I want to get back into real estate. You call the commission. It's been more than 2 years. What are they going to tell you? Call Lane. Get back in another pre-licensing school. So is it worth paying the $45 every year? I can't really answer that for you. Y'all, this is the last in-person class or face-to-face person that I taught that I had two people that were there because their license were expired for more than 2 years and they had to start all over. Ouch. Pay the fee. It's $45. Questions on reinstating an expired license? Always pay the fee. There's a whole section about provisional brokers. The big thing that we know about PBs is you guys got to be supervised by a BIC. Remember your training wheels. You can't ride your bike without your training wheels. Your BIC is your training wheels. Provisional brokers can do just about anything that a full broker can do, as long as you're supervised by a broker in charge. So as a PB that's supervised by a broker in charge, can you list a property for sale on behalf of the firm? Yeah. Can you help a buyer buy on behalf of a firm? Yeah. Can you give or receive referrals? Yeah. You can do just about everything that a full broker can do, as long as you're under the supervision of a BIC. Some things that we've talked about that you can't do. You cannot charge a fee for doing a BPO. You can't hold on to earnest money deposit. You cannot be designated opposite of your broker in charge. That's pretty much it. So once you get your training wheels, you can do just about everything that a full broker can do. When you're paying that renewal fee each year, make sure you have the funds in the bank. If that renewal fee declines, they may consider that disciplinary action. So make sure you got the $45. in your account before you pay it. So we said a few minutes ago that the Real Estate Commission's physical year is July 1st to June 30th. The renewal period is my opportunity to pay my renewal fee. And that is every year between May 15th and June 30th. Also, within the renewal period, we have got to complete CE. The deadline for CE each year is June 10th. We've got to do CE, continuing education, every year that you want an active license, no later than June 10th. June 10th is the deadline. It's always the deadline. We do 8 hours of CE a year. We do a 4-hour update course. The update course is the same material for all licensees across the state. The update course is the Real Estate Commission's opportunity to get the same message out to all of us. It doesn't matter what school you go to. You're going to get the same update information. Then we also get to do a 4 hours elective. And the elective is a topic of our choosing, as long as it's got approval for CE credit. There are a cajillion topics out there on the elective. So when you guys start taking your CE, when you start doing your elective, I always recommend that you do an elective. What's your niche? What area do you want to learn more about? And kind of use that to, you know, 2 birds, 1 stone, knock out your CE and get further information about the whatever part of your career you want to learn more about. There are a cajillion topics out there, constantly changing, updating. So we do 8 hours of CE a year. Here's some good news for you guys. Well, let me say something else about this June 10th. Let's make sure we're good with this. First off, June 10th, every single year. Schools usually start ramping up CE again about the fall. So August, September. So you have from fall until June 10th to take 8 hours. Is that reasonable? Is that asking too much of us to do 8 hours of training in what, 9, 10 months? I think that's pretty reasonable. Sometimes agents want to wait till the last possible minute. June 10th, the classes are jam-packed full. It blows my mind how many people sign up for CE on June 10th. I do not recommend that, because if something happens and you cannot complete your CE by June 10th, assuming you've paid the fee, that means on July 1st, your license is inactive, and it will remain inactive until you can get caught up on your CE. And remember what I just said, most schools don't start offering CE again until the fall. So if you go inactive on July 1st and you can't find a CE class until August, you're inactive until you get that done. Everybody with me? So please, 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 y'all, please do not wait for the last minute to do CE. A lot of agents will tell you we tend to slow down about next week, right before Thanksgiving. We don't stop, but we tend to slow down a bit. So you have the winter up until the spring market where you're looking for something to do anyway. Why not do your CE during this time? Y'all, please, you guys promise me that you won't wait till June 10th. Promise me. Y'all, back in my admin days, I was kind of the lane of a school. And I'm telling y'all, on June 11th, my phone was blowing up. What do I do? What do I do? Be prepared for your license to go inactive on July 1st and remain inactive until you get it done. Okay, $1 million question. I'm so sorry, you guys. I should have done this sooner. You guys as provisional brokers don't have to do CE until your second renewal period. So the first renewal period, once you get your license, the first June 10th, you do not have to do CE. You get your first year off. You do have to pay the fee. Always pay the fee. Post-licensing and CE are two different things. We do 8 hours of CE a year. We do 90 hours of post-licensing. They're two different departments down at the Real Estate Commission. Is that good news? Do you guys like that? You don't have to worry about CE your first renewal period. Just pay the fee. The thinking is you just got out of pre, you just got out or in the throes of post. So you have the current information. You can choose to do CE your first year, but you don't have to. Questions on CE? Yeah.
So once you finish the CE, do you have to like let the commission know like, hey, I'm done? Or you could just
The-
automatically.
The director of the school will submit your completion. Yep, so you don't have to do anything. The director will submit it. You will want to, once you're done with CE, give it about a week and then go to the commission's website, log into your account, make sure that it's posted, make sure that you got credit for it. But yeah, the director does that for you. Yes, ma'am. You might be on mute. Where are you?
I was wondering if we did
You might
see,
be.
sorry.
Kind of.
So basically, I'll just send in the chat.
18 months is how long you guys have to do post licensing. You have 18 months to do post, you do CE. When does your 18-month clock start? When you get your license, it'll tell you. So the date on your license starts your 18-month clock. You can roll over elective. The question that Jordan was, thank you, Jordan. The question is, can you roll over CE credit? And you can roll over elective. So if you do 2 electives this year, then you don't have to worry about elective next year. But we all got to do the update each year, because again, that's the commission's opportunity to get one message out to all of us. At last count, there was like 106,000 licensees in the state of North Carolina. Yeah, y'all heard me right. 106,000 licensees in the state of North Carolina that have to do CE each year, have to renew, as long as you want to continue next year. Do I teach CE? No. I do pre and post. Did I see another question? Another?
I was about to ask like what would be required to become an instructor, but then I remembered, I think something about 2 years full time.
You gotta
Or
have some experience under your belt. Yep.
Yep.
Goals. Question comes in about when you can start post. You got to have a license to start post. So you can't take a post licensing class while you're waiting for them to mail your license. Like, you got to have the license. So once you pass that state exam, then you can, looking at, there you go, Ashley. I love it. If 106,000 other people can do it, then so can we. Yes. But no, you can't start post licensing until you get that license. Again, you guys, very important dates for your calendar. Please don't let the June 10th deadline get away from you. CE is June 10th every single year. You have to pay the fee by June 30th, assuming you want an active license. If you want an active license, you pay the fee and you do CE, fee and CE. We're getting a lot of questions about post licensing. Again, it's 90 hours. There's 3 topics. You can complete them in any order. You don't have to go in a particular order. Commission doesn't care, just as long as you get them done. You have 18 months from the day you get your license. For post licensing and CE, just FYI, they may grant an extension for a hardship. So if you can prove a hardship, they may give you an extension. But guys, a hardship is not, I got busy and I forgot. A hardship is something like active military deployment or major medical issues. Or interestingly enough, in 2020, COVID. They actually gave hardships in 2020 for COVID, for CE and post licensing. They gave extensions. Even though they gave an extension for CE, you still had to pay the fee by June 30th. Always pay the fee. Questions about CE, post licensing, renewal fee, current license? I'm not sure, Fred, with that 30-day waiting period. I don't think you need, I'm not sure what that is, but. Last little piece is on timeshares. Again, timeshare is one of those things that's covered under both license law and commission rule. I don't know that you need to know these. I just put these here to seem official. Article 4 of license law is on page 20 of your book. That covers timeshares. Section 58B of commission rules on page 87. That also covers timeshares. Unless you plan on working for a timeshare, we just got to get you through the class. Who remembers what we remember about timeshare? Yes. 5, 5, 5, 10. Jazz hands. What am I talking about? The simplest definition of a timeshare is the right to occupy a unit during at least 5 or more separate time periods over at least 5 years. Does everybody hear and see at least? 5 is the minimum. Is it a timeshare if you have 10 separate time periods over 10 years? Is that a timeshare? Yeah, because it's at least 5. What if it's 2 separate time periods over 3 years? Is that a timeshare? No, because it doesn't meet that 5. Everybody see that? At least 5 separate time periods over at least 5 years. The buyer has a 5-day recession period. They have 5 days to rescind their contract. If they put down any deposits, they'll get that money back. The timeshare developer has to keep the deposit in their trust account for 10 days. If the contract's rescinded, they need to be able to refund that to the buyer. If the contract's not rescinded, they can move that money from their trust account to their operating account and use it to do what they do. And this is the only time that the real estate commission will get involved with matters of money. They have the power, they have the authority to fine a timeshare developer up to $500 per violation. Questions? Guess what, you guys? That's it. Y'all now know what I know. We're not done yet. Please don't leave. Class is still going. So we're getting ready to take a break. When we come back, can you be sad? You can come see me in post. We'll have just as much fun in post as what we do in pre. Maybe even a little bit more in post. Post is so much more relaxed. So this is what's going to happen. We're getting ready to take a break. When we come back, we're going to Kahoot, our last Kahoot. We're going to Kahoot. This is our license law and commission rule Kahoot. Let's see how we're doing. We need to do a little segment on safety. It's so important that we understand agent safety. And then the very last thing we'll do in our last hour is talk about the rules and expectations for Thursday. So if you guys can please hang in there with me one more hour, I promise you I will get to it. I promise you we'll cover it. So go take a break. When we come back, we are wrapping this thing up. Isn't that crazy? So many lasts. Last time you have to hear that bell, last hour of class, last screenshot for attendance. Does it feel like we just met not too long ago? It's amazing how fast this stuff goes, isn't it? Here we are. All right, so let's go ahead and take attendance. Before we finish up, I almost forgot to share. Wouldn't that be something? And here, I'll just make this where you get, well, let's do that. There is some good information for you guys in Appendix A. Remember I said the current book is in Learn, Test, Pass in the welcome section, but that doesn't mean there's not still some good stuff in Appendix A about license, law, and commission rule. The key point review is pretty accurate, guys. Remember, if you have any conflicting information, I'm not saying it's totally accurate, but if you're looking at the key point review and you have any conflicting information, refer to the license, law, and commission rule book and Learn, Test, Pass. Learn, Test, Pass has the absolute current. But for the most part, I think this is a really good key point review because there's a lot of information in license, law, and commission rule. That's on page 729 of your book. And then there's also a student quiz that I think is also really good as well. Again, any conflicting information, always refer to Learn, Test, Pass. I got a quiz for you guys in Learn, Test, Pass as well. There's a separate section on license, law, and commission rule. Questions, comments? Everybody good? Okay, y'all get your phones. We're gonna Kahoot. This is our license, law, and commission rule Kahoot. Again, if you don't want to play on your phone, you don't have to. I do suggest that you play in your mind. There's your QR code if you want to access it that way. I think that's the easiest and simplest way to go. If you're on the website or the app, your game pin is 124-4716. Once you're in, you put your name. Nicknames are okay. I don't mind. If you want to remain anonymous, I may ask you who you are, but I'll look at Fred's little avatar. Is that a brain freeze? That's awesome. Everybody in that wants to play? Don't let your phone go to sleep. Look, Ashley's already got a graduation cap. She's ready to go. Graduating from real estate school. Everybody in? Last Kahoot. License, law, and commission rule. North Carolina Real Estate Commission may take disciplinary action against a licensee who ten seconds. Oh. They may take disciplinary action. Does that mean they're going to? There's that teeny tiny word that means a whole lot, isn't it? They may take disciplinary action if you violated a provision of license, law, or commission rule. They may also take disciplinary action if you got yourself in trouble with another occupational or licensing board. So we talked about convicted of a felony or misdemeanor, or being disciplined by another licensing board. An example being a South Carolina real estate license. Questions on this one? Let's see who got it right the fastest. Abby was the fastest, followed by M and Haley, Aubrey, and Yeet. Question number 2, a real estate license must be renewed no later than every June 30th. When do we renew our license? From May 15th to June 30th, 45 days to pay currently $45. So we renew. How do we renew our license? You can show me. How do we renew? With money. We renew by paying the renewal fee. Paying means your license is current. M crept up, Aubrey crept up, Abby's hanging on, Haley and Yeet. We just shuffled around a bit. Question number 3, what is the deadline for CE? Ten seconds. Deadline for CE every single year is June 10th. June 10th, June 10th, June 10th. Y'all, that date needs to be up there with like your birthday and Christmas. June 10th. Do CE each year by June 10th. If you don't, assuming you've paid the fee, that means on July 1st, your license is inactive. 18 months is post-licensing. July 1st is the start of the commission's fiscal year. June 30th is the end of the renewal period. Questions on these dates? So switched up again. Aubrey's up top now and Haley. Abby's still on. Jordan climbed up. Fifi. Looks like Lex is our highest climber, up 6 places. July 1st is the start of the commission's fiscal year. Their fiscal year goes from July 1st to June 30th. Meaning they don't operate on a calendar year. That's what a fiscal year means. They don't run from January 1st to December 31st. They go from July 1st to June 30th. Other questions? In North Carolina, all real estate brokers must ten seconds. I need somebody to tell me what's wrong with the blue one. This hurts, doesn't it? What's wrong with the blue one? This is how they like to trick you guys. What does the word current tell you? Current means you've done what? Current means you have paid the fee, and that's all it means. A current license has everything to do with the fee. It has nothing to do with education. You're current because you pay the fee. I need, well, okay, what's the right answer? I can never place an ad. I got to include my firm's name. Failure to include the firm's name is a blind ad. We cannot have a blind ad. I need questions on this one. As long as we get it now. See what they like to do. See what I like to Kahoot, because this gives me an opportunity to say, y'all don't fall for that on your test. When you see the word current, think currency. Yeah, and that's the problem with Kahoot. I know you can't change your answer. So I don't know if that's a problem or not. I kind of wish they stopped you guys from changing your answers on the exam too. We'll talk about that. Anybody ever change the right answer to wrong? Stop it. Maybe that's a good default. Everybody good? Current means currency. Well, this should be interesting. Let's see what we got on this next screen. Abby's back up on top. Haley and Bina, Aubrey and Jordy. Bill's our highest climber, up 8 places. Question number 5, under license law, provisional broker is authorized to. Nine seconds. Original broker is authorized. You can list for sale. You can help buyers as long as what? As long as you're under the supervision of a broker in charge. I can never, ever, ever sign a sales contract on behalf of a client. I'm only a special agent, which means I have no authority to bind. Questions on this one? As a provisional broker, actually as a full broker, you can only be paid by your affiliated firm, your affiliated broker in charge. You cannot receive payment directly from. Abby's still on top. Haley and Bina. Jordy Bill crept up. Will's our highest climber this round, up 3 places with his little flower hat. Very pretty. How long from receipt does a provisional broker have to deliver trust funds to their BIC? Ten seconds. How long from receipt do you have? Run, don't walk. Get it to your broker in charge immediately. Provisional brokers cannot walk around with somebody else's money. Thank you for nobody saying the green one. The green one makes my eye twitch a little bit. So thank you guys for not saying that. There's so much wrong with that. 3 days of receipt, 3 days of contract formation is how long the escrow agent has to deposit it after receipt or contract formation. PBs cannot walk around with somebody else's money. When they hand you, they say, we're in the throes of negotiations. Here's my earnest money deposit. Hang on to this for me. Get it to your BIC. Questions? Okay. Big reveal. So we got our 3rd place is Jordy. Good job. For graduation cap. Our 2nd place is Haley. And our 1st place is 5491. You will have to tell me. Oh, Abby, I see. Okay. I'm sorry. I missed your big reveal. I messed that up for you. I'm so sorry. Runners up are Lee and Jack. Man, you deserve better than that. You're a Kahoot winner. Transfer that to the exam on Thursday. How about that? Will that work? There you go. Questions? Y'all put your pencils down. Put your pencils down. What we're going to do now is we're going to talk about safety. You are not tested on safety. However, I think safety is one of the most important topics that we talk about in this class. So what I have first off is a video. The National Association of Realtors provided us this video on safety. So we're going to watch that and then we'll have a little conversation about it. But I need you guys to start thinking about your personal safety. So that's what this video does. Will y'all give me the thumbs up? Make sure my volume's up. Make sure the thumbs up when it starts that you can hear it.
As a real estate professional, you are in a unique position that most working professionals never face. In your business, you often share your contact information openly with others, meet unknown clients, and walk through vacant properties, to name a few. It's because of the unique nature of this business that it's critical for all real estate professionals to have personal safety protocols in place that you follow every day, with every client, every time. So what kind of safety protocols should you implement into your daily routine? Here are a few to consider. When meeting a client for the first time, do not meet a new client at a property right away without first having an initial meeting at your office or a public space, like a coffee shop. During the initial meeting, make copies or take photos of the client's driver's license and pre-approval letter for your records. This precaution allows you to keep a record at the office of who your clients are, their information, and a calendar of appointments. When first meeting with a new client, you should discuss the types of real estate they're interested in and walk them through the safety protocols you have in place for all clients. Now you can arrange showings, meet them at properties, and schedule open houses to help them through the biggest financial decision of their life. When viewing a property, it's okay to ask your client to drive separately. This is a safety precaution for you as much as it is for them. Not to mention you might both have appointments to go to before or afterward.
Hey, this is cute.
As you tour a property, walk behind your client. This routine safety measure allows them to see the room first and make their own impressions. Many agents do not go into attics, garages, or basements as an additional safety measure. But encourage your client to look around and let you know what they think. It is a safe practice to only show vacant properties which might not have electricity during daylight hours. This allows you to see what safety hazards may exist, like a loose floorboard or any defects the house may have.
It's got potential.
When holding an open house, advise your clients to board their pets and remove jewelry, family photos, credit card receipts, artwork, prescription drugs, and any other valued possessions from the home in advance of the open house. This is just one way to look out for your client and to keep their property and belongings secure. Keep a record of who entered the house by asking everyone who walks in the door to sign in with their name and phone number or show a photo ID. There is something to be said about safety in numbers. Consider bringing along a colleague when holding an open house. If there are several potential buyers walking through the home, even better to have 2 agents on hand to answer questions and keep an eye on things. Safety is an important part of real estate. Be prepared and follow the protocols and processes that have been put in place to keep you and your clients safe. For more information and additional resources, visit www.nar.realtor/safety.
All right, so before I open this up for questions, first off, I want to make sure we understand the importance of safety. What you just saw in the video were just some examples. You guys are encouraged to set up your own safety protocols. Your firm may have a safety protocol that they expect you to follow, but we need something into place, you guys. As the video indicated, you're opening yourselves up to the public, and unfortunately, not everybody in the public has good intentions. So I need you to always be cautious, safety first. There is no amount of commission worth your safety. And if you don't believe me, just ask your family in about 30-40 minutes, and I'm sure they will agree, they will verify. So the number one question I always get, can I have my concealed carry? And the answer is, of course you can. If you have your concealed carry when you're doing open houses, when you show property, can you? Of course you can. Your firm may have a policy says that they won't allow you to carry in the office, but that only regulates you walking through the front door of the office. You guys with me? If you don't have your concealed carry and you don't have experience with guns, please, please do not try to carry a gun. Before you carry a gun, you need to be comfortable. You need to have experience. There are other things you can do. You can carry mace. You can have the alarm on your car. I have a flashlight that serves as a taser. Does it look weird for a real estate agent to have a flashlight, especially for poking our heads in crawl spaces? So flip of a switch and it's a taser. So there's other things that you can have besides guns. I do not want you guys to put others or yourself at risk because you're not experienced with the gun. Everybody good with that? And remember too, you guys, anything could work as a weapon if you were in a dangerous situation. So you can put your keys between your fingers and use that. I think every single one of you on this call, gentlemen included, should take some kind of self-defense class. I just stopped sharing my screen for a minute. I think you should take some kind of self-defense class, kind of teach you some basic moves about how to get away, how to get out of somebody's grasp. You know, bottom line, you guys, we want you to be able to get away. And I think that's the big picture to keep in mind. Okay, what questions do you guys, what have you guys thought about safety until right now? What thoughts or comments do we have about safety?
You can share your location as well with people you trust.
Exactly.
Or let them know where you have your open house that day. Or
Exactly. So, you know, when I do an open house, I leave a post-it on the coffee table for my husband to let him know the address that I'm at. If I have a day of like 12 showings, he has the list. So he knows property number 1, 2, and about what time I'm supposed to be there. We hate to think like this, but if I go missing, if they have my itinerary for the day, they have a better chance of finding me. Does that make sense? They knew I made it to property 3, but I never made it to property 4. So they know something happened between those two. So I agree, Aubriana, if your significant other or a friend or a family or even one of your peers or your coworkers, if they know when you're out showing where you're supposed to be and when, then that could save everybody precious time. Thank you.
My friend's part of an all-girl group, and they have tracking that they follow each other with their iPhones when they're at open
Okay.
houses.
So you got like the GPS locator or something? So yeah, you can turn that on when you're showing and allow somebody access. Turn it off when you're not, right? Because it's nobody's business where you are 24/7. But yes, when you're, you know, so that's a great, that GPS tracking location, as long as you have your phone on you. But again, they can find, they can know where you were more recently, then it can help them find you faster. What else?
Julie, I liked the idea of not going into like the small spaces or the attics, and also letting the other person be in front of you.
You lead them. And I agree, Samantha. I think that does two things. So let's say, for example, I'm showing a buyer a property and all the bedrooms are on the second floor. And I walk into a bedroom and say, what do you guys think? My only way out is that second story window, isn't it? I've allowed myself to be trapped. So you lead them. The second thing that does, y'all, it's awfully hard for the buyer to imagine themselves living there when I'm standing smack dab in the middle of the room, right? I kind of take away from that experience. So let them lead through the house, let them go through the home. You get behind them going up and down stairs. You know, I like that as well. I think that's a good, if you at all possible, don't park in the driveway. If at all possible, park in the street. Now, I understand that it's not always possible, but if you can, park in the street, because when you pull in a driveway and then they pull in behind you, now you're blocked in. What other questions about safety do we have? Or comments? Have you guys thought about this?
I like that it said to drive separately, because I didn't know if it was just a customary thing like to drive your clients. So I like that, you know,
Yep.
They wouldn't be offended or anything.
You can have that, you know, I like putting buyers in my car once I've had the opportunity to meet them a few times. I never put a stranger in my car. So once we've been out, seen a few properties, I meet you a few times, I feel like you're serious, da, 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 da. That's my preference, you guys. You can always insist that buyers follow you. What I want you all to promise me is that you will never get in the buyer's car. You don't ride with them. So either you drive separate or they ride with you. I like buyers in my cars though. In my car, I don't know how many cars I have, just one car. I like buyers in my car because that gives me an opportunity. This is just me personally, but that gives me an opportunity when we're driving around from point A to B, B to C, C to D, to talk about things like due diligence fee, earnest money deposit, what happens when we go under contract. So this gives me an opportunity to have that discussion, but I also know that's not always possible. So if I can't have it in between showings, then I got to find a time to have it. We got to have time to discuss it. Do you guys hear in the video when they talked about having conversations with your sellers? I think they specifically said open houses, but this applies for all showings. Don't allow your sellers to leave valuables out. Don't allow your sellers, y'all, sometimes people go open housing to scope the place out. Is it worth coming back later and robbing, right? So don't, you know, stuff that can easily slip into a pocket, like prescription meds, that kind of thing. Y'all ready to have your mind blown? One of the biggest complaints last year down at the Real Estate Commission was buyers and agents helping themselves to the prescription medications in the medicine cabinet and the kitchen cabinet. They're on video opening cabinets and putting prescription bottles in their purse. I would tell my sellers not to keep your prescription medication in the medicine cabinet and the kitchen cabinet, because you know where everybody looks for those things. And besides the medicine cabinet, the kitchen cabinet, the closets, those things that convey, buyers should be encouraged to look at them. Don't they have the right to know the size of the closet and what the inside of the kitchen cabinet? So they should be opening. They can't go in personal stuff, dressers, desks, that kind of thing. But if it's going to convey, they should be encouraged to look in them. So tell your sellers, put your prescription meds up, your jewelry, anything that can easily walk away. I know we watch a lot of crime shows, don't we? Y'all don't let that psych you out. But on the same respect, you know, have I ever been in a situation where I felt unsafe? I have. There was one time that I felt uneasy. I'm not going to say uncomfortable or I felt the need to, you know, get my mace out or anything, but I was well on alert. I was very aware, and, you know, I got out of that situation, obviously, before it could escalate, if it was going to escalate. So I didn't feel uncomfortable. I just felt a little, you know, I think one of the best things we can do is listen to that little voice inside you. And when that little voice says something's not right, y'all, please don't ignore it. Please don't ignore it. I know we may feel silly. We may feel, oh my gosh, but again, I don't care if you feel silly or not. At the end of the day, I want you to be safe. I think especially as new agents, it's easy to fall in the trap. So let's say you're on office duty and the phone rings and you have a buyer that says, I'm sitting in front of your listing at 123 Main Street and I want to see it. Isn't that so easy to slam the phone down, run out, hop in your car and run over to 123 Main Street and show it to them? You need to proceed with caution. I always think anybody you're meeting anybody for the first time, you need to encourage to meet them in a public place. If you can't get them to come into your office, then meet them at a Starbucks or something. What's the one tool I have that I can use? What's the one thing we have to do before I can well, I don't have to, but I can use as my excuse before we show this property that I could do at Starbucks before we get to this certain point in time?
Disclosure?
Yeah. Yeah. So why do I have to meet you at Starbucks? Well, I have an agency disclosure that I need to go over with you. So let's go have a cup of coffee. My treat. Isn't that kind of a good excuse? So now, guys, if they're not willing to meet you in a public place, I would question their intentions. If they're not willing to meet you, I would question their intentions. Again, you guys are welcome to have your own safety protocols in place. Your firm may have policies, but remember too, you guys, the big picture for fair housing says what we do for one, we do for all. So once you create your safety protocol, what you do for one, you need to do for all, so you don't get yourself in trouble with a fair housing violation. Other comments or thoughts?
Oh, one thing I was gonna ask is about like cameras. Like, say if you have a listing, is it like customary for like the firm to usually put cameras in whatever like house that they have?
Not the firm. The seller may have cameras. The seller can have video. The seller cannot, should not have audio without both parties' permission. So is it on, especially today, y'all, it is almost 2023. I need you guys to conduct your lives as if you're on camera, because you know what? There's a really good chance that you are. So when you're showing homes, when you're showing properties, I mean, Nicolette, to that point, the cameras were how they caught all these agents and buyers last year taking prescription meds. So be prepared to see cameras when you go inside a listing. Ring doorbells, I mean, absolutely. Trust that little voice inside your head. Trust that instinct. That goes back to our caveman days, doesn't it? If that thing says run away, that means there's a big woolly mammoth coming after you and you need to run away. It's there for a reason. Ladies, please don't try to wear stilettos when you show properties. It's not easy to run away. And at some point you might be walking around in somebody's backyard. Have you ever tried to walk around, especially in this kind of weather? All you're doing is aerating their yard for them. You're not helping yourselves. Again, you want to dress, be prepared, exit strategies. Even when you guys go to a home to show it, you know, when the buyer gets out of the car, they're looking at curb appeal. They're looking at, oh, that's a nice front yard. We need to be looking, is there anybody lurking behind their bushes? Who's across the street, right? We need to help our buyers by looking at everything else, at our surroundings, at the environment. There's some crazies out there, y'all. And I hate to say it, but I don't know another way to say that. That's exactly right. September is the National Association of Realtors has designated September as Safety Month. So they always do, like, that's when they released that video that you just watched. They always do some kind of promotion, some kind of reminder. This time of year, especially, you know, we just changed the clocks back, what, a week or so ago. And so we don't have as much daylight. So you might be, if you have to show a property at 5:15, you're in the dark. So just have your flashlight with your taser, have your protocol. And you can always bring somebody with you. Bring a coworker. When I'm showing property evenings and weekends, I almost always have my husband with me. If I promise him pizza, he'll come with me. So he stays in the car, you know, he doesn't get out and get in my way. He can't because he doesn't have a license. So he stays in the car, but you know what? They see him there. You can have somebody, they don't have to be licensed to sit at an open house with you. If you take an unlicensed friend to an open house, it's your duty to make sure that they understand their role. Can that unlicensed friend sell that house at the open house? No, they are there for you. So you can have, there's safety in numbers, you guys. Lane makes me do a night class once a year. It's coming up in January. We're almost here. And it used to be when we did this thing in person, we were walking out an empty parking lot at 10 o'clock at night. And I had everybody, I put everybody take turns on Julie duty. which means I asked the whole class, one person from each class, to stick around and walk out in the parking lot with me, just so I'm not walking out in an empty parking lot by myself. There's safety. And the one lady looked at me. I mean, I'm not a tall person. I'm like 5'3" in the right shoes. So she was like, 5 foot, 100 something little thing. And she was like, well, I don't know what good I'm going to do. And I'm like, it's safety in numbers. There's now 2 of us. There's now 4 sets of eyes, or 4 eyes, 4 ears. You guys with me? So that doesn't hurt to ask a friend, family member. Anything else? Safety, just something for you guys to think about. Please do not disregard your safety. At the end of the day, I want to be able to come home tonight and have dinner with my husband. So what do I need to do to be able to achieve that goal? How can I get home tonight? Y'all don't let dollar signs drive you. If you bring your husband in, he needs to understand his role. Anybody unlicensed, they need to understand their role. I just leave mine in the car. Anything else? All right, I need to take attendance again. I got a lot of you that I can't see. I need everybody to sit up, center in your camera. I need to be able to see you so I know if I have to hunt you down later today or not. Looks like I'm going to have to hunt a couple of you down. Always fun. Okay, so I am taking attendance. Everybody smile real big for me one last time. Cheese. Keep your cameras on. I need you guys to stay. You're here now, but I need you to stay here too. Fair enough? The last thing we're going to do is discuss the rules and expectations of my exam. Maybe you have taken the pre-licensing exam with another instructor. Guess what? This is how I give my exam. Everybody with me? Is there a difference? Yes. So I'm going to ask that we hold all questions until the end. I promise you I will answer all your questions. But if you give me just a minute, I probably will answer them before we get to them. So we're going to hold all questions until the end. You guys feel this guy's pain? Is this how you feel right now? Welcome to real estate. I love this guy. To me, he says it all. All right, what does Thursday look like? Thursday is test day. We have no more instruction. So Thursday is test day. One of the first things we do before we can begin the exam on Thursday is a check-in process. I will talk more about that on the next slide. I need to have a little bit of one-on-one time with each of you so I can check you in. And I'm going to start this process at 8 a.m. I'm logging on at 8 o'clock Thursday morning. The earlier you guys can log on, the better. There are 41 of you and 1 of me. So the longer, the more time we have to do this. I don't need all of you to log in at 8, but I need you guys to start logging on at 8 a.m. so we can get everybody checked in and start the exam as close to 9 as we possibly can. I'm usually pretty good about getting us in by like 9:05. I think one class, it was like 9:07. So as long as you guys can be here early and cooperate. So what I'm saying is I need you guys early to log on or to check in. I cannot start the exam until everybody is checked in. So that's why I'm encouraging all of you to be here as early as you can to get you checked in so we can start on time. For the check-in, we got a little one-on-one. I need to see your basic calculator. I need to see the calculator that you're going to use from your exam. And I'll probably ask you to show me, both sides, make sure you don't have any formulas written on it. I cannot let you use your phone for a calculator, and you cannot use a calculator that stores formulas. I almost always have somebody shows up and says, can I use this T183? This is all I have. No. Can I use the calculator on my computer? No, I told you guys on day one to go calculator shopping. So you still have time. I need to see the calculator that you're going to use. You're going to have a pen or a pencil or a purple crayon. It makes no difference to me. Some kind of writing utensil. You guys will start with 2 blank pieces of scratch paper. I need to see your scratch paper. Like, you're going to show me both sides, front and back. You're going to show me that it's blank. Y'all, this is important. Your blank paper stays blank until we begin the exam. So once you check in, you can't start writing stuff on your scratch paper. The blank paper has to stay blank until we begin this exam. If you're on a laptop, let me clean up my space a bit. If you're on a laptop, I will need you to show me your desk space. I will need you to show me where your desk is clear, where you don't have things taped to it. If you're on a desktop, I understand you can't do that. So we're going to roll under the honor system. You're going to put your right hand up and say, Julie, I got nothing on my desk. I got nothing in my area that would be considered cheating. So I need a nice, clean space. I will allow you guys to have drinks, snacks, cough drop, mints, gum, whatever. Whatever helps put you at ease. During the check-in, I also need to see that your textbook and your notebooks are with you and close. So you're going to say, Julie, this is my textbook. I'm going to put it right here beside me. I'm going to put it behind me. Why, you ask? Because I allow you guys to take bathroom breaks, and I want to make sure your book is not in the bathroom. My only other option is to not allow bathroom breaks. You guys tell me, will you show me your book? Will you show me your notebooks? Okay. I also need you guys to have your phones off. Can we all agree that off and silent are 2 totally different things? I need you guys to turn your phone off before you check in, because as I have learned, a lot of us do not know how to turn our phones off. And if I have to wait for all 41 of you to figure out how to turn your phone off, we're not going to get started at 9 o'clock. So show me. You're going to hit the button and you're going to show me that it doesn't light up, right? You're going to hit the button and show me that it's off. So we'll do a little one-on-one time. This is what takes time. I'm going to go ahead and thank you guys for your patience Thursday morning, and I'll probably thank you 20 more times before we begin, because I know this process is tedious, but this is one of the downfalls of being online versus me being able to be in the room with you. Fair enough? So we're going to do some one-on-one, get all of you checked in. By the way, if y'all think I'm tough, wait till you get to PSI Testing Center. They ain't got nothing on me. They're not patting you down yet, but you know. When you guys log on to Zoom, I need you not to have any virtual backgrounds. I know some of you have your virtual backgrounds. Some of you kind of have the blurry effect behind you. I need all that off for test day, because I need to be able to see who or what is behind you, so nobody's back there giving you answers. So I need virtual backgrounds off. I also don't want dimly lit spaces. Again, I need to be able to see you. You guys are front and center in your camera the whole time, except for when you're not, and I'll talk about that in a second. When we begin the exam, you're only going to have 2 tabs open on your computer. So you guys are going to log on to Zoom like we do every single class. You log on to Zoom and you shut down your email. When we're ready to give the exam, I will put a link in Zoom chat to ClassMarker. When you click on the link, you access the exam. So during the exam, you only have 2 tabs open, Zoom and ClassMarker. You don't open other tabs, particularly Google. You guys, when we take the test, I won't be sharing my screen. I'll show this in just a second. I won't be sharing. So you guys will be able to minimize Zoom and kind of move it off to the side so it won't be in your way. I don't want you guys to be distracted by your peers. You don't have to watch each other. I will be watching you. By the way, I'll have help on Thursday. Anika Bartley is going to sit with me. Anika does post licensing for Carolina School of Real Estate. So I'll introduce you guys to Anika on Thursday. Let's call Anika your carrot. Y'all want to go to Anika's post licensing class? Use her as motivation to get through this. So Anika and I will be watching you. Our cameras will be off. All of your cameras will be on. This is also really important. You guys will never, ever unmute yourselves. The only communication, the only person you can communicate with during the exam is me. And the only acceptable form of communication is via direct message. If I see you guys talking to anybody else in your room, I can only assume that you're cheating. I can only assume that you're talking about the test. And if you're talking about the test, you're cheating, and the commission says, I take your exam right there on the spot. If you need to leave in front of your camera for any reason, you've got to communicate with me in a private chat. Julie, I have to go to the bathroom. Julie, I got to get a bottle of water. Julie, I got to close the blinds. Julie, I got to adjust the thermostat. I've heard all sorts of things so far. If you leave in front of your camera for any reason, I need to know. Somebody says you read questions out loud. First off, you're not going to be able to do that at PSI Testing Center. But for my purposes, I'll allow it. I don't think it's right. I don't think I'm preparing you for PSI, but I've gotten so much kickback from this, I've given up. So I will let you, if I can tell that you're reading a test question, can we see the difference? You can only communicate with me and only versus me having a full-blown conversation with somebody else in the room. Can you guys see the difference? So as long as I can tell that you're reading the test question, your mouth is slightly moving versus you having a conversation. Again, you guys, you're not going to be able to do that for PSI. They're a lot stricter than I am. So we get everybody checked in. I put the link for the exam in the Zoom chat once I have everyone checked in. Once you begin your exam, you get 4 hours. Passing is 75%. When you hit submit, it says, are you sure? And you say yes, and boom, pass or fail. It's like that. Once you have finished and you've seen your results, you're done. You can log out. You do not have to wait for me to excuse you. So once you're done and you've seen your results, you're free to go. You and I will both get an email with your results. You don't have to ask me if you can go. When you're done, you're done. So we put the link in the Zoom chat. You click on it. First thing you're going to see is something that looks like this. Pretty much says this is a closed book exam. You can't take pictures. You can't record. No technology, no recording devices. You guys cannot discuss this exam with anybody. That would be considered cheating. Bottom line, any violation, you'll fail the grade for the entire course and you'll be reported to the North Carolina Real Estate Commission. Again, they say if I suspect you of cheating, I don't have to prove it. I have to suspect you of cheating, and I'm free to take your exam and let you work it out with the Real Estate Commission. So you read this on test day and you click start. That email from Lane that you guys use to access class, there's that class marker tutorial. If you haven't looked at that yet, please do. Kind of help you know what to expect with class marker. You see one question per screen. You can bookmark a question and go back to it. Remember, I always suggest you guys bookmark the math. Always save the math for last because that's what's going to take you the longest. Every screen also has a link on it that says see all questions. And when you click on that, it's going to tell you which ones are answered, unanswered, or bookmarked. The very last thing you do before you hit submit is click on this and make sure everything says answered. Please do not submit without making sure that if you skip something, if you bookmark something, please make sure the last thing you do, you can do it throughout the exam if you want, but particularly the last thing you should do is click on See All Questions. There's also a countdown clock on the screen, starts from 4 hours and work your way down. Unfortunately, the only way I have to communicate with you guys is to unmute myself. So please rest assured that I'm not doing so unless I absolutely have to. And when we get down to about 5-10 minutes left, I will generally unmute myself and encourage you guys to watch your time. Keep an eye on a time. But keep half an eye on your countdown clock. So you finish it up, you hit submit, and boom, you see a 75% or higher. That's a good day. Yay. When you pass, Lane will be in touch with further instructions. They'll send you your certificate of completion. That certificate of completion is what you need to finish your application to the Real Estate Commission. We talked about that. We looked at going to the Real Estate Commission's website, clicking on apply for a license. When you get, and be patient with Lane, you guys, she's a busy gal. Most of the time she's good about getting with you guys that day, but you know, Friday morning, possibly, I don't know her schedule. I don't know how busy she is. So just please be patient. Keep the email, even if you're not ready to submit your application, keep that email from Lane. Again, that's your ticket. The certificate of completion is your ticket to get into the state exam. So keep that email from Lane and check your spam too. I don't know why, but sometimes Lane winds up in your spam. If you don't pass, but you make at least a 50%, you are eligible for the retake on Monday, the 21st. Lane will be in touch with you with those instructions. Again, please be patient with Lane. She will be in touch with you. If you make below a 50%, Lane will be in touch. Bottom line, what I'm telling you, you can expect to hear from Lane, pass, fail, or eligible for the retake. Just be patient with her. I think it's important that we all understand, remember what I just said, we cannot discuss the specifics of these exams. The Real Estate Commission does not allow you to see what you pass or fail, what you get wrong or what you get right. For those of you that did the midterm exam, you'll remember you got that report afterwards that kind of gave you the breakdown. This is how you did in each topic. So that's what you will get, kind of a general overview. But you can use those to identify your areas of weakness. But we can't talk about the specific questions. Me and you to each other. That applies for your state exam as well. I'm getting a lot of questions and I will address them in just a minute when we're done. So what if we begin this exam on Thursday and one of us loses power? Or what if one of us loses internet? Or what if something goes wrong during the exam? First off, everybody take a big deep breath. It's okay. Before we begin the exam, before I give you the link, I will provide my phone number in the chat. And I will ask you guys to write my phone number down on your blank piece of paper. So when you begin the exam, the only thing on that paper will be my phone number. We're going to all write that down together. If we lose connection for any reason during the exam, I don't know when, how, who, I don't have a crystal ball, but what I do know is we will get through it. I promise you, we will get through it. So if you lose power, if you lose internet, please just reach out to me and we will get through it. Y'all always remember to breathe. So the number one question I'm getting is, how many questions are on an exam? 112. If we pass but would like another opportunity to take it for practice, can we do the retake? You need to reach out to Lane about that. I can't answer that. What other questions do I have about our exam on Thursday? So we're all going to log on. We're going to check in. We're going to start with blank scratch paper. And once we begin, I'm your only friend once that test begins. I'm it. I'm all you got. Sorry. I am the only person that you can communicate with. Everybody good with that? Question comes in, only 2 blank sheets of paper. That's right. You have to start with 2. The reason being because that's what PSI tells you to start with. If you need more than 2, you send me a private chat that you're going to get another piece of paper and that I need to see front and back. Okay, so if you need more than 2, all you got to do is just send me a private chat and let me see it. Nicolette, did you have a question? Or a hand? I'm sorry.
You don't mind if you see us eating like a sandwich, right? Or some rice and beans?
If you need to eat a sandwich, you know? Are the answers written on the sandwich? Are you eating a grilled cheese with the formulas etched into them? Y'all laugh, but people get pretty dang creative with cheating. I swear, if you took all this time to learn the material versus figuring out how to etch formulas in your grilled cheese sandwich, you probably wouldn't need to.
Alphabet soup.
Oh.
Have it all spelled out.
Y'all looking at tea leaves, looking for formulas. You know what? That's great. Heavily tested units, 7, 8, 9, and 10. License law and commission rule, 14 and 15. You're going to have some questions from all of them. I never remember if there are 8 or 10 math questions. So let's just err on the side of caution and say 10. It's 1 o'clock, you guys. I know if you need to go, go. I got just a few more things to say, not about. So, you know, if you need to go, go. I'll still record. If you can give me about 5 more minutes, though, we're close. And again, I thank you guys for your patience. See how tight this class is? We do not waste any time in a 75-hour class, do we? We use it all of it. Any other questions about the exam, about Thursday, what Thursday is going to look like? Yep, see you Thursday morning, 8 a.m. I'm ready for you guys too. I got the big travel cup of coffee, so I don't have to run to the coffee pot every minute. Question comes in, what if you don't pass Thursday and Monday? You got to retake the class. I know Lane will let you retake it for a discounted rate. You cannot go on to PSI Testing Center until you get a certificate of completion for pre-licensing. You got to finish, you got to get through pre before you can go to a state. So again, I'm glad we have today's weather today and not Thursday, but that doesn't mean that, you know, things happen. I don't know what can happen, but what I do know is we will get through it. So y'all take a big, deep breath. May I offer some advice? May I offer some tips and tricks? Yes, you need to have the math formulas memorized in order to do the math problems. Y'all remember the math workbook, page 1 of the math workbook. I even tell you what math you need to know for Thursday. May I offer you guys some tips and tricks for Thursday? May I offer some advice? Yes, please, God, say something. Okay. The very first, the best piece of advice I can offer you guys, all joking aside, the absolute best piece of advice I can offer you guys for Thursday morning is to breathe. Seriously. When you guys feel, oh my God, I've never seen this before in my entire life, stop. Close your eyes, put your head down for just a second, and take a few big, deep breaths in through the nose, out through the mouth to get yourself grounded again. Are you doing yourself any good if you're blah, way up here somewhere? You got to get yourself grounded. Y'all have got to remember to breathe. In addition to breathing, I need you to read. Breathe and read, read and breathe. Are we all good? Every single word means something, not just in the question, but all 4 answer choices. So keep half an eye on your time and make sure you read every single word. I've addressed this, but it's worth saying again. Stop changing your answers unless you are like 5,000% sure that it's wrong. Y'all, back in the day when we were in person, Lane and I hand graded these tests. I've seen people fail because they changed too many answers. Will you guys promise me? Julie, I promise I'm not going to change something unless I am beyond certain. Please stop changing your answers unless you're sure. As we said, make sure when you're done, you click on that see all questions and make sure everything says answered. If something is unanswered, you need to, make sure you address that. I also really do think you guys should save the math for last. Whenever you come to the math bookmark it, see all answers so you can see what's bookmarked and you can go back to it. Take your time, but remember to watch your time. I have no control over the clock and class marker. When that clock and class marker hits 4 hours, class marker ends the exam. So they start the 4-hour clock. And when they're done, when it's 4 hours, your screen just disappears. It just goes away. So keep half an eye on your time. Again, with about 5-10 minutes left, I'll unmute myself and remind you guys to watch your time. If you got questions unanswered at the 10-minute call, just go in there and put B or C or A or whatever your favorite. Don't leave anything unanswered. So between now and Thursday morning, y'all got to get your nose out of the book at some point. You cannot spend the next day and a half doing nothing but studying. The last thing I want is you guys to show up Thursday morning over it before you ever begin. So if you study, I give you the test on Thursday, I'm like, oh my God, here's the stuff again. Y'all give yourselves some break. Honestly, you guys, I think at some point on Wednesday, y'all need to put the book down. You need to do something Wednesday night that you find relaxing. At some point, you've got to know that you know what you know. And you got to put the book down and give yourself a break. What does mama tell you? Get a good night's sleep. Don't try to pull an all-nighter. It's not going to work. So get a good night's sleep. I also think you should try to eat breakfast ahead of time. That says a light meal. That doesn't say go to Golden Corral and hook up on the buffet, right? Get you a light meal. We don't want your tummy grumbling during the exam. That could be distracting to you. My preference is snacks. But again, if you need a meal during the test, I'm not going to tell you no. And the last thing I have to say is best of luck to everybody. Thank you guys for your time. I appreciate this class. I think overall this was a good class. So I appreciate you guys, your questions, your comments. Another thing you'll hear from Lane after the exam, she'll send you a survey. We ask you guys to complete that. It's anonymous, so you don't have to worry about hurting my little feelings. But I encourage, because we need feedback, myself and the school, how we can grow, how we can offer a better product to you guys. So please look out for that survey from Lane. And once you pass, keep me posted. Let me know. I love hearing from you guys when you're going to PSI. Better yet, I love hearing from you guys when you pass. So absolutely keep me posted. Guys, when we're done on Thursday, when you're getting ready for your state exam, I'm still here for a tool. I'm still here as a resource. So as you're studying for that state exam, I'm still available to you guys. So please don't hesitate to reach out to me. Let me know if there's anything I can do to help. One more thing, just real quick. Again, thank you guys for your patience. This is how we're going to look on Thursday. So I won't be sharing my screen. Do you guys see all your mates? Say hi to everybody. Say hi. What you guys can do, if you look at the top right, you guys see that little dash where you can minimize your screen. Everybody see that? So when you minimize Zoom, it makes it, and now you can kind of tuck it off to the side. And then that way you guys aren't distracted again. And Nika and I are watching you guys are watching your exam. I don't want you guys looking at your peers. I make every effort that I possibly can to eliminate distractions during the exam, because I know some of you have worked really hard to be here. So I want to do what we can to eliminate distractions, which is why we don't unmute, which is why we only communicate via chat. Yes, you can bookmark the math, so you can save it for last. You can bookmark each question. Please, here, let's look at this. Please go to the email from Lane that you use to access class. You guys see this email? You click on this every day to access class. Here's your Zoom link. Right here, where is it? Right here is a tutorial on Class Marker. So if you're not familiar with Class Marker, please watch that. It'll show you how you can bookmark a question, how you can make sure you've answered everything. So if you haven't done that yet, please go through the tutorial to give yourself that. I literally have nothing else to say. Did y'all think it was possible? Shut her up, right? Thank you guys so much. Let me know if I can answer any questions over the next day and a half. Otherwise, we'll see you guys 8 a.m. sharp Thursday morning. So we can do this, knock this out.
Thank you, Julie.
Thank you so much. I'm so excited for Thursday.
Good. I like that.
Thank
I like that. Thank you guys.
Thank you.
Thank you, Julie. You were a really wonderful person, a great teacher.
Thank you.
Thank you.
Thank you for saying person first. I'm a that means a lot. Thank you. I've enjoyed you guys. This has been a good one.
Have a good day, guys. Good luck.
Thank you. Bye. We'll see you Thursday.
Thanks, Julie.
Hey. Are you guys awake? Brente? Naya? Did you hear the exam rules and expectations? Then I need you to watch the recording. I need you to watch the recording. Failure to follow the rules and expectations will result in you losing your exam. So watch that recording when it's available on our YouTube channel. Okay. Brente?